let's hold it for now, and then let's see how quickly we can get someone over to deal here. Okay. All right. Thank you.
I'm just getting some people named. Everybody, I don't call you if I don't mention you. Then good morning to you. I'm just naming the people that I need to find out if they're in the right place.
Okay.
Dennis Ventura. Dennis Ventura.
I'm here.
Good morning to you. What is your? Is that your full name, sir?
Yes, Your Honor.
You're on the docket. Okay, very well. And then another person is Lawrence Childs King. Is Lawrence Childs King on the docket? Lawrence Child King.
He was in the waiting room, Your Honor. His name is, okay.
He's here. Let's see if we can unmute him. Unmute yourself, state your name, and start your camera. Childs King, unmute yourself, start your camera, and state your name, please. Good morning to you. All right, get out of the room. If you can't unmute yourself, start your camera and state your name. Lawrence Childs King. I'm sending you the prompt. All right, they leave. They left. All right.
I see him in the waiting room, Judge.
I do too again. Lawrence Childs King, good morning to you.
Good morning.
Are you officer? Childs King? Lawrence Childs King?
Yes, I'm here. You hear me?
Are you an officer, sir?
Officer? No.
All right, let me get a full name. I don't know if you're in the right spot or not. Is that your Childs King is your last name?
Childs King, yes, sir.
Do you have a case number?
Give me 1 second. Let me look it up.
Oh, it's in warrant status. You got to go to Judge Kennedy, sir. Kennedy.
Judge Kennedy?
Yeah, you have case number SP 1250784, counts 1 and counts 2.
Judge Kennedy. Oh yeah, SP 147754991.
See that one. SP 1477. Go ahead.
5491.
You have a couple of one has a hyphen in between it, and the other just has a space. So I don't know how you spell your name.
Yeah, it's supposed to have a hyphen in it. Childs hyphen King.
Okay, so this one needs to be corrected.
Excuse me, sir. You need.
Hold on, sir. Hold on.
Okay.
You hear me talking?
No, but I told you because not speaking English.
All right, I told you I'm going to get you an interpreter.
Thank you.
All right. Yeah, you have to go to Judge Kennedy. Judge Kennedy, her Zoom ID is 435, Mr. Childs King.
Okay, thank you. I appreciate it.
All right, if it's nothing further, so I wish you the best of luck. And make sure you let them know that that one case is spelled without the hyphen. And then you have some other cases that are in there with the hyphen, okay?
Okay.
So they need to know that so they can make sure they bring up all your cases.
Okay,
Best of luck to you.
Thank you.
On the iPhone, it was an iPhone, but I don't believe, okay. Once we get these two people named, we'll On the iPhone, good morning to you, sir. What is your name, please, or ma'am? Can you unmute yourself and start your camera and state your name, please? What's your name, sir? Good morning to you.
I'm letting it only, sir.
You're who? Only. You're back. All right. Liddell only. I already checked it. You know, you gotta check on your. Let me let this last iPhone in. Here's the Arabic interpreter. That's quick. iPhone, unmute yourself, start your camera, state your name. Good morning to you. Somebody else on the iPhone, I'm sending you the prompts. Good morning to you, sir. What is your name, please?
Lamar Glover.
No, not you, Mr. Glover. Good morning to you.
Good morning.
On the iPhone, you have to unmute yourself, sir. I just walked away. All right, let's keep going. Good morning, Ms. Rahal.
Good morning, Your Honor.
Let's start it up. Let's open it up, Mr. Officer. Yes, sir.
Good morning. The Honorable Judge Sean B. Perkins is presiding. While Zoom is in session, there will be no driving, no inappropriate appearance of any kind, no head wraps unless they represent religious purpose, no hoodies, no talking over the judge while the judge is talking. Please place your phones on mute. Court is in session.
All right, good morning, everyone. What I'm going to do is do the best I can to get you out as fast and efficiently as possible. And I'm going to try to get you out in order that you came in. The iPhone just unmuted himself. Good morning to you, sir. What is your name, please?
Diammani Lately.
Latham?
Lately.
Good morning to you.
Good morning.
What's your name, sir?
Lucas.
Lucas. Yes, sir. All right, Mr. Lately and anybody else that's scheduled for trial, we're going to give the officers a half-hour grace period from 9 o'clock to 9:30. If the officer does not show, we'll get you out of here. If the officer does show, then we'll get you in a breakout room with the city, with one of the attorneys, and get you an updated offer, okay? All right. Let's get going. This is this. Are you ready, Ms. Williams Law?
Excuse me, Your Honor.
Yes, Your Honor.
Who said excuse me?
Hold of here. I would like to start to want to adjourn this, please.
You're gonna get a chance, Mr. Ochoa. Let me, everybody's gonna go in the order that they came in. That's another thing. I'm gonna start, I'm gonna take you in the order that you came in, the best I can. I'm gonna get you out of here as fast and efficiently as possible. Please be ready. No slouching, sleeping. Be appropriately addressed, and let me name this one last person. Let's call this 313-854-7279. Good morning to you. What is your name, please?
Hey, Jerry Graham.
Graham?
Yeah, G-R-A-H-A-M.
Good morning to you, Mr. Jerry Lee Graham.
Good.
All right, good morning to you, sir. All right, this is the city of Detroit versus Joshua Andrew Lotto. To strike that, state of Michigan versus Joshua Andrew Lotto, case number SX405-1708, counts 1 and counts 2. Appearance for the record, please.
Yes, Your Honor. My name is Peter Torres. My P number is 68242. And I imagine this is an arraignment. He's in the Oakland County Jail, and I'll waive his presence if that's okay with the court.
Good morning to you. I will waive the client's presence. It's not an arraignment, it's a pretrial, so what is your kind of want to do?
Your Honor, if we could, I was seeing on the docket here, it said it was in warrant status, but if the court's showing that it's a pretrial, I would just ask for an adjournment for 30 days until he's released from the Oakland County Jail, and then we'll appear in court.
Come back on the 19th of September, the 19th of September. If there's nothing further, Counselor, have a very good day. Best of luck to you.
Thank you, Your Honor. Appreciate it.
Ms. Rahal, good morning to you. Can you state your name for the record, please?
Good morning, Nurse Samira Rahal, interpreting Arabic for the court.
All right, can you raise your right hand, please? Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court, not divulge confidential communications, so help you God?
I do.
And do you swear or affirm that you will interpret from English to Spanish? Strike that. Do you swear or affirm that you'll interpret from English to Arabic, Arabic to English to the best of your ability?
I do, Your Honor.
All right.
I'm here for Jilan Mukhtar.
All right. Let me call. This is the city of Detroit versus Mukhtar Ali Dalan. Case number SP 1748362, counts 1 and counts 2. Appearance for the record, please.
Owensby Jr.
Mr. Berry.
Good morning.
Madam.
Samira Rahal, interpreting Arabic for the court. For Jilan Mukhtar. Tina.
Mr. Hall, you gotta put it in Arabic.
That's what I'm asking him to give your name so I can't. سيد جيلان مختار. هيدي القضية ولاية ميشيغان مقابل جيلان مختار. رقم القضية SP 117483621. أعطينا اسمك سيد.
مختار علي جيلان.
Mukhtar Ali Jiran.
Your Honor, for purposes of arraignment, my client would stand mute.
بالنسبة لأسباب ليش هو موجود هون رح يكون صامت حضرة القاضي.
Not just to put your client to have, I'll give your client a $0 bond. I'm gonna put you in a breakout room with them, get them an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
اوكي رح يدخلنا على غرفة خاص لتحكي مع المحامي وتحاولوا تحلوها. إذا ما قدرتوا تحلوها بتأجلوها ليوم تاني، يوم محكمة. فبس بالإشارة تكبس عليها بندخل على الغرفة. سامع؟
اوكي على اين اكبس؟ في اي مكان؟
Where do I touch when it comes? What do I touch? الإشارة شايفة بيقول join. شفتها وصلت؟ شايف من تحت join؟
ايه
اكبس عليها.
ضاعت علي. اوكي
بعد اكبس على
اوكي على مربعات مكتوب عندي.
yeah. اوكي join وين بيقول ادخل؟ هيدا الازرق من تحت. يلا بسرعة اكبس عليها من تحت وين بيقول.
He's in there.
Okay. All right.
All right, let's pass the matter Gar, Ali, Octavia Gar,
It's Octavia.
Octavia, I'm sorry, ma'am. Good morning to you.
Good morning to you.
Okay. Thank you.
City of Detroit versus Octavia Gar, case number SB 174-9980, counts 1, 2, 3, appears for record.
Your Honor, good morning again. Pauline Soroki on behalf of the defendant.
Sir, state your name for the record, please. Ms. Garth, are you there?
Oh, I'm sorry, Octavia Gar.
All right. Today is date and time set for a pre-trial. Ms. Garth, Mr. Roby's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room with her. Let us know what you want to do when you come out, okay?
Okay.
Join the room. We'll pass the matter. Wednesday, are you there? Marcus Owensby?
Yes, sir.
Morning to you, sir.
Good morning.
Do you have a middle name, Mr. Owensby?
Marcus Allen Owensby Jr.
City of Detroit versus Marcus Allen Owensby Jr. Case number SP 1746171. Here for the record, please. That would be Mr. Zoran.
Lady Judge Bob Zoranek for the defendant. Sorry about that.
All right. Good morning, Mr. Owens. We state your name for the record, please.
Marcus Allen Owensby Jr.
All right. Today is the date and time set for a pre-trial. Mr. Owens, we speak to Mr. Zoranek in the breakout room. Mr. Zoranek is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out, okay?
Yes, sir. Thank you.
Let's pass the matter.
Okay.
Counselor Green, what's your client's name again?
Nolan Gresens, last name Gresens.
Let me show you.
Officer Janelle Thomas Paul from Roosevelt Outlaw to dismiss.
All right. Good morning, Ms. Snyder.
Morning, Your Honor.
All right. Anybody ready? I'm gonna go ahead and start letting people in and naming these people.
Amended attempted felonious assault, making that a felony of the 3rd degree, and that he'll also enter a plea as charged to count 3, which is the misdemeanor 1, domestic violence. In exchange for those guilty pleas, the state is going to dismiss the strangulation count 2 charge. There is no agreement on sentencing.
All right. Mr. Perry, is that accurate?
It is, Judge.
Mr. Salac, they're telling me you're going to change your plea to 2 counts, 1 amended and 1 misdemeanor. Before I get you to change the plea, I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
I am 58 years old.
How far did you go in school?
Graduated.
Can you read and write?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in these cases?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you've received from Mr. Perry?
Very much so.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
I did.
Did you read this and go over it with Mr. Perry?
I did.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of attempted felonious assault as a felony of the third degree that carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. The prison term is not mandatory nor presumed to be necessary. The second count is one of domestic violence, a misdemeanor of the first degree that carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties?
I do.
In addition to those maximum penalties on the felony charge, you are also subject to a mandatory period of post-release control, which means that if you are sent to prison upon your release, the adult parole authority will supervise you for not less than 1 year nor more than 3 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
I do, sir.
But it's not mandatory that you're sent to prison at all. The court does have the discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow as well. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
I do, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury, and if you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
Ms. Hyatt.
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt that with respect to amended count 1 and count 3, that they both occurred on June 5th of 2024, while this defendant, Raymond Salac, along with my victim, Shannon Lawrence Phillips, were at their residence in Hamilton Township, Warren County, Ohio. With respect to amended count 1, that the defendant did engage in conduct, which, if successful, would have resulted in the crime of felonious assault involving serious physical harm. With respect to count 3, he did on that same date and location did cause harm to Shannon Lawrence Phillips, a household member.
All right. Mr. Perry, anything on those facts?
Nothing, Judge.
Mr. Salac, did you hear the statement that was read?
I did, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, sir.
And what is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Mr. Salac. We'll come back in a few weeks and do sentencing at that time. Ms. Hyatt, is there anything else?
No, Your Honor, thank you.
Mr. Perry?
Nothing, Judge. Thank you.
All right, thank you all. Thank you. Ms. Hyatt?
Oh, thank you.
Mr. Brenner, call your witness.
Thank you, Your Honor. Defense would call Dr. Joy McGee.
Do you swear affirm the testimony you'll give in this proceedings will be the truth? I do.
Good morning, doctor. How are you?
Good morning, Judge. Fine, thank you.
So the ground rules for today are that your report has already been admitted into evidence and your qualifications have been stipulated to.
Okay.
So we're probably not going to spend a whole lot of time on your qualifications, and you don't feel like the attorneys are not going to feel like they need to cover everything in your report in it. I've already read it a couple of times, as recently as this morning. We're just going to highlight some of the stuff that is in your report, but either side can ask as many questions as they want. Do you understand that?
Yes.
All right. Could you please state your name and your professional address, please?
Joy McGee, and the office address is 1244 Nellis Road in Fairfield.
All right. Go ahead, Mr. Brenner.
Thank you, Your Honor. Dr. McGee, as Judge Oda indicated, basically the report's already been admitted. So I'm just going to ask you some questions to kind of highlight some of your findings in your investigation. Okay.
Okay.
When did you evaluate Mr. Williams?
I saw Mr. Williams on two occasions, on January the 30th of 2025, and then again on February the 13th.
And you met with him at the Warren County Jail, is that right?
I did.
And when you evaluated Mr. Williams and prepared your report, what information did you have available to you?
I was provided with the discovery packet from the prosecutor's office, and which included the offense reports from the Warren County Sheriff's Department as well. And there were also some videos that had been provided from the prosecutor's office.
Did you review all of those materials?
I did.
You obviously met with Mr. Williams. Did you speak with anyone else before preparing your report?
I did. I spoke with his mother, Ms. Sharon Williams, and I also reviewed the competency report that had been prepared previously by Dr. Nichting.
Okay. And is it your understanding, was Mr. Williams' mother present for at least some of the incident that led to these charges?
It's my understanding that, yes, she was present and in the car with him.
Okay. And what information was she able to provide to you?
So whenever I contact collateral sources, I always do a brief clinical interview. So she provided information about Mr. Williams' developmental history, educational history, as well as his mental health history and her observations of his behaviors at the time of the offense.
Okay. And were you able to find any mental health history for Mr. Williams prior to this incident in February of 2024?
No. His mother did not report any formal mental health history, and there were no records to obtain.
Okay. And fair to say that since this incident, Mr. Williams has been diagnosed with a mental illness?
He was diagnosed during his time at Summit Behavioral Health Care after being found not competent to stand trial.
What to your knowledge was he diagnosed with?
I believe he was diagnosed with a psychotic disorder.
How, I guess, common or not common or unusual is it for those kind of symptoms to manifest themselves at Mr. Williams's age?
So the, I would say typical age range for the manifestation, like the first appearance of symptoms for severe mental illness, is typically between 20 and 25. That's what we see a lot.
Okay. So it's, I mean, maybe on the higher end, but he's within the range of when those symptoms might start to manifest?
Yes.
And when you met with Mr. Williams at the jail, what was your impression of his demeanor and his responses to your questions?
Well, initially, as stated in my report, the corrections officers informed me that he had been very unresponsive to their interactions, and so they were doubtful that he would speak to me. So when I went back on the pod that he was in, he was just sitting quietly, but he was responsive to my questions and to my explanation of why I was there.
And at the completion of your report, what is your conclusion as to Mr. Williams's mental state?
So after my 2 interviews with him and gathering all of the collateral information that I had, my opinion was that he did not know the wrongfulness of his actions at the time of the index offenses.
Okay. And so he suffers from a mental disease or defect and did not know the wrongfulness of his actions.
Correct.
And what led to your conclusion that he did not know the wrongfulness of his actions?
Well, his description of the offense, which I'll just say he admitted that he had kind of a poor or spotty memory of the actual offense, but his recollection and then all the collateral information that I reviewed, including the video recordings and the information from his mother, also went into my opinion.
And you are aware that Dr. Dreyer also completed an evaluation in this case, correct?
Yes.
Have you seen her report?
I did look it over, yes.
And she had come to a different conclusion than you did. Is that right?
She did.
Okay. Why do you feel that your interpretation of the available information is the correct one?
Well, I would say I feel comfortable and confident, in my opinion, based on the information and data that I had, the process that I go through, both clinically, but also in terms of my thought process as I prepared these reports. And I feel that my opinion was derived from a rational, logical, critical thought process.
And you indicated you did review videos of the incident.
I did, the videos that were provided, yes.
And you reviewed police reports?
Yes.
And statements?
Yes.
And so what ultimately led you to the conclusion that Mr. Williams did not know the wrongfulness of his actions?
So I could summarize by saying, but for the presence of his psychiatric symptoms, this would likely not, he would likely not have engaged in these unusual and bizarre behaviors. And so the fact that his behaviors were unusual, bizarre, completely out of character, or inconsistent with his previous behavior and functioning in the community, and also the fact that those behaviors were precipitated by psychiatric symptoms, led me to the conclusion that at the time of the offense, he did not know the wrongfulness of what he was doing.
Okay. And During your investigation in the preparation of your report, did you become aware of a head injury that Mr. Williams suffered before this incident?
I did. During my 2 interviews with Mr. Williams, he talked with me and explained what happened that led to the head injury he experienced.
So in your professional opinion or experience, and is that kind of a head injury? Could that be a trigger for these kind of symptoms?
That's a good question that I gave a lot of thought to. And it's kind of like a chicken and egg situation. Certainly a significant head injury can manifest with what appear to be psychiatric symptoms, hallucinations, delusions, odd behavior, mood lability. So head injuries can precipitate those symptoms. But the fact that Mr. Williams had some symptoms, even though he was never formally diagnosed, the fact that he had some mental health symptoms before the head injury, and the fact that his psychiatric symptoms continued for months after the head injury led me to rule out the head injury as the cause of the symptoms. I'm not a medical doctor, neurologist, but that was my thought process.
Thank you, Doctor. I don't have any further questions for this witness.
Ms. Trainer?
Thank you, Your Honor.
Actually, let me jump in first. So I understand, Dr. McGee, you and Dr. Dreyer do not fundamentally disagree that Mr. Williams suffers from a severe mental illness, right?
Correct.
And that includes a psychotic disorder.
Yes.
You guys agree that he had no mental health history prior to this incident of any significance?
He had no formal diagnosis, yes.
That you both acknowledge that he had some behavior changes following the head injury that Mr. Brenner talked about, which included some confusion and some unusual behavior, although the exact contributing factor to that is a little murky, right?
Correct.
You both agree that he exhibited symptoms on the day of this offense of the severe mental illness, such as confusion, disorganized thinking, and delusional beliefs.
Correct.
Right? And you agree that after all of this, he's been compliant with his, well, you wouldn't know that because you haven't seen him compliant in his medications, right? But I thought I saw something in your report about that.
I believe during,
question.
while he was at Summit, he was compliant. And then when he was back at the jail, I think he was compliant.
And you both agree he doesn't have any significant history of violence or inappropriate interactions that even come close to being what he's charged with in this offense, right?
That's correct.
Okay. So Dr. Dreyer identified some facts from which she concluded, based on those facts, that he knew Mr. Williams knew the wrongfulness of his actions at the time. One of those facts were that he concealed his identity. Did you consider the fact that he may have concealed his identity with the hoodie being zipped up? Did you consider that when you wrote your report? And also, one second, Ms. Clipper, there's a folded up packet of stipulations on my desk. Can you bring me that? Go ahead.
With the stipulation that this is many months ago,
okay.
I don't remember the fact that the hoodie was zipped up being a part of my conversation with Mr. Williams. And I don't remember that being a part of any of the videos that I watched either. So I don't know that I knew that.
So if you were to accept the fact that he concealed his identity as being true when he entered this residence, if you accept that as being true, what impact on that, if any, does that have on your opinion?
So the fact that the hoodie was zipped up, I would need to know kind of the purpose of that. If indeed the purpose was to conceal his identity, then I would agree that that would fall in the column of did know the wrongfulness, versus if the hoodie just happened to be zipped up, or if that's the way he typically wore it, or he zipped it up because there was some delusional belief that it had to be. So I mean, I would need to know more about why it was zipped up, the context of that.
Okay. So also, Dr. Dreyer identified the fact that he fled the scene and that he fled from police. So if we are to accept again that those two facts as being true, that he did flee the scene and he did flee from police, what effect, if any, does that have on, or would that have on your opinion?
So I would disagree with the characterization that Mr. Williams fled the scene.
Okay.
My memory of our conversation and the way he described the situation and the way his mother described the situation was that after he had been in the house for a little while, like she kind of investigated and then asked, and said, we need to leave. And so they left, and I think ended up at another McDonald's or whatever. So
I mean, you saw the Ring video. They left in a hurry.
yes. Mm-hmm. But I didn't interpret that. I interpreted that as a function of, at some point, his mom had said, we need to leave.
Okay.
I didn't interpret that as him fleeing the scene.
Okay.
And then, again, based on his recounting of the offense, I think he was at a McDonald's and saw the police officers. So again, I didn't interpret kind of what happened as him fleeing the scene, because at some point he said he did get out of the car when he saw the flashers and that the officers had their guns drawn.
Okay. Also, one point in this case is, and this was identified by Dr. Dreyer yesterday, that when he was questioned by law enforcement about being in the victim's home or about being in the car, that he denied both of those. If he did, in fact, deny that he had been in the home and he had been in the car to police, does that have any effect on your opinion?
So again, based on my memory of his recollection of the events, that would actually be consistent, because he told me that he pulled over or got out of the car when he saw the police officers, because he thought maybe he had, I think he said, ran a red light or, had something malfunctioning with the car. He did not associate the officers being behind him and asking him to get out. He did not associate that with anything that had happened at the victim's home.
Finally, Dr. Dreyer identified that he declined to provide a DNA sample. If in fact that's true, does that have any bearing on the opinion that you gave in this case?
Again, I would need to know more about why.
Well, I'm just telling you to accept that as true. He declined to provide a DNA sample to the police. Does that have any effect on your opinion?
Well, if he declined, it depends, again, on why. If he declined because he had some sense that that would be used as evidence against him, then yes, that would go into my column of did know the wrongfulness. But I can't rule out that a denial to provide a DNA sample may have been connected somehow to his disorganized and delusional thought process at the time.
Okay. Some of this may be my ignorance about the right terms to use, so feel free to correct me on this. If we were to assume that this event is taking place am I allowed to say break with reality, that that Mr. Williams has a break with reality during this time?
That's fair, yes.
If we assume that there is a break with reality that starts before he arrives at this house and goes past the time that he is involved or arrested by law enforcement, if we assume a break with reality during that time, do I understand correctly that break with reality will sort of come and go? Wax and wane, I think, is the term that I have heard.
For some people, yes, I have done evaluations where people have been psychotic, but there have been intermittent times where they were aware of their situation, of their surroundings. They were aware of who they were. They could have, a back and forth conversation, but they were still psychotic. So the short answer is yes.
Okay, and getting close to the end, during the interview, he's doing some weird things with his hands. Do you remember that when there was nobody in the interview room with him? It's just his hands were sort of wandering about. He did have the hoodie zipped up during that interview.
Mm-hmm.
Do you have an explanation from a psychiatric or a psychology standpoint? What is that?
So I do remember that, and I think, I don't know, I have an explanation for it, but Mr. Williams did make a statement like he felt like he was talking to his father the whole time, during his psychosis. So I think one of the explanations that I had when watching the video was that that was just an outward manifestation of some hallucinatory, delusional things happening. And he was like interacting with whatever was happening, whatever stimuli he was responding to.
So again, if you accept my break with reality theory that began before the incident started and really continued on into his interview with the police, do you agree with that there was a break with reality from before this started to happen until through the end of his interview with the police? Do you agree with that?
Yes, the data that I have suggested that his psychosis had started before the offenses and continued throughout the time of the when he was in jail and then when he got to Summit. So
it continued during some time, at least while he was at Summit, right?
Yes.
Okay. All right. I was going to do the same thing that I did with Dr. Dreyer, which is have her look over the stipulations. Do you want me to do that after you're done, Ms. Tranter?
It's up to you, Judge. I don't have an objection to keep
It
doing
always
it now. That's fine.
All right. So, Dr. McGee, these are the stipulations, these front 2 pages, 3 pages. If you could read those over for a minute. My question afterwards is going to be, these are what the parties have agreed to are the facts in the case. What I'm going to ask you afterwards is whether or not any of that changes your opinion or if any of those facts are significant to you. Those are the 2 things that I'm going to ask you.
Okay.
But take your time and review that. While the doctor is reviewing it, we do have a housekeeping item, a couple of housekeeping items.
Yes, sir.
I don't have an exhibit list, but the exhibit list, I think from memory, our Dreyer report is 1.
Yes.
McGee report is 2.
Correct.
And what's 3?
3 is, we would have to look at the disc. It's one of the discs. I can't remember which one I marked as 3 and 4.
Another trip to the office, Ms. Grobo. Can you get the discs?
I think 3 is the surveillance video and 4 is his interview with police.
That's my recollection too, I think. But I guess
And we are going to mark Dr. Nichting's report, which is dated April the 23rd, 2024, as Exhibit 5.
Yes, sir.
Okay. Do you have those reports? What do you have?
I have 1 and 2.
Okay. I don't know. So Let me see if I. Don't get all tight shoulder on me. I'm going to print this to the court printer. Is there another one? No, something. Okay. All right. So we do know that home security videos are 3.
I guess I would mean his interviews 4 then.
His interview
Yes.
before,
Process of elimination suggests that that is 4.
probably still in your drive.
All right. And I have those somewhere. I have both 3 and 4, and then 5 is coming off the printer right now, very quietly. And we'll go ahead and mark that. It'll look exactly like this, but it's not the reefer's envelope. Here we go, Debbie. They do not trust me with a stapler. And if you want to write on that, Doctor, you can.
Okay. Okay. All right, and tell me your follow-up question again.
So what of those facts, if any, stuck out?
So I would say the 2 that stand out to me will be on the bottom of page 2, where it says that the defendant was shown a photo of Allen, the victim, and denied knowing him or ever seeing him before. And then after that, defendant was asked to provide a DNA sample and refused to provide one. So again, those stand out to me because they certainly could fall into the column or suggest that the defendant did know the wrongfulness, but because I didn't I'm trying to think in my interviews, I don't know that I asked him specifically about when he was shown the photo of the victim or why he refused to provide a DNA sample. So I would not want to infer what that meant without additional information.
Okay. Do any of those facts change your opinion?
None of the other facts changed my opinion, no.
Okay. Ms. Tranter, you may inquire.
Thank you, Ron. I'm Dr. McGee.
Good morning.
Judge went over quite a few of the things that I was going to go over with you, but I do have a few follow-ups for you, okay? Shouldn't be too much. So you met with the defendant twice, right?
I did.
Okay, so in your report is dated February the 14th of this year.
Correct.
And according to your report, your date of evaluation was January 30th, and then also the day before your report, which is February the 13th.
Correct.
Correct? Had you already started on your report the day you went back to meet with him on the 13th?
I did.
Okay. Was there a specific reason you went back the day before your report? Was there some information you were missing?
I decided to go back because Mr. Williams' memory of the offense was so spotty. And I talked to him about this during the first interview. I wanted to see if he recalled any additional details. So I went back to see if he had recalled any additional information, if our conversation had sparked any memory, and also wanted to observe his mental status.
Okay. And did he provide any more details on the 13th?
He did not provide any additional details. He continued to say that there were gaps and he could not recall.
Okay. And in your report, you noted that you considered him not to be a reliable historian because of this memory gap.
Correct.
Is that fair? Okay. But you would agree with me that he actually recalled a great deal of the events surrounding the actual incidents, correct?
Yes, as we talked and I asked follow-up or clarifying questions, he did kind of give me a fair amount of context and kind of details about what happened before, during, and after.
Right. I mean, he went into so much detail. He knew that he picked up his daughter from grandma's house in Columbus, right? They had gotten ice cream, correct? That they went to a park. He was trying to tire her out. Actually stopped and got her some toys. He remembered all those details, correct?
He did, yes.
Okay. Stating he had gotten lost in Cincinnati, correct?
Correct.
Okay. And that he was using the GPS on mom's phone to try to find directions.
Yes.
Correct? Okay.
Yes. I'd say his memory for the context of the offense was decent. Where things got spotty, I'd say was between the time I'm guessing we pulled into the driveway of the victim's home and kind of what was going on in the home. He had some memory of that, but not cohesive.
Okay. So do you consider the point where he pulled into the driveway of the victim to be the beginning of his psychotic break, I think is what the judge used?
No.
When did it start?
Well, I would not be able to pinpoint when the psychotic break started, but based on the information I obtained from his mother, it appeared that he was disorganized, and disorganized is the best word, from I'm guessing maybe a couple of few hours before, where things like he just couldn't figure out where he was going or how to get there. I would say the disorganized piece started there.
Okay. He's not from this area, correct?
He's not.
Okay. From Columbus?
Yes.
So it wouldn't be considered unusual for him not to know where he's going in an area he's unfamiliar with, correct?
Certainly if you're not from an area, you wouldn't know your way around, but as a person who is a non-mentally ill person would have relatively organized ways of navigating and finding their way around an unfamiliar place.
Wouldn't you consider using a GPS to be an organized way of finding your way around someplace?
My memory of what he said is he was using GPS, but that he was still getting off and on the highway and still getting lost. So I don't know that the using of the GPS was actually extremely helpful. And then when it couldn't use it, things just got more chaotic.
Let me ask you this. Did you consider that piece of data in forming your opinion?
The fact that he used GPS? It was a data point, but not something that was particularly significant for whether or not he knew the wrongfulness of his actions.
Okay. You didn't think it was significant?
Not relative to the legal question.
Correct. Okay. All right. Did you consider other alternatives for this sort of block of memory, this gap in memory? Did you consider other possible alternatives, such as malingering?
Other than psychosis?
Yeah.
Yes. So I do think that the spotty memory is a limitation of this evaluation. And certainly, I do consider what benefit the defendant might have to not remembering the offense. I also considered the previously mentioned head injury, like what effect might that have had on his memory process?
Did you give him any tests for possible malingering?
No.
All right. Now I want to be sure to, seems like you relied on a lot of the information that he gave you in your evaluation. That's fair to say, correct?
Yes, also in comparison to the collateral information that I had.
Okay. And I want to talk about the collateral information in just a moment. Did you consider any sort of possible intoxication during these events?
I always ask if they had been using any kind of substances before or during the offense. And
how did he respond to that?
Mr. Williams said he had no history of substance use. Oh, he said he had a history of occasional use of alcohol and marijuana, but had not been using anything prior to or during the offense.
Okay. And did you ask Mom about that when you spoke to her? Sharon Williams, I believe is her name.
I don't remember if I asked her about his substance use.
Okay. As part of your collateral information, did you watch the police interview with Miss Williams?
I don't remember a police interview with her. I don't remember a video. I could be wrong. I have a vague memory of an audio. But
It may have been an audio. And I don't have that right in front of me to say if it was a video or an audio, but there was a police interview with Miss Williams.
Yes.
Correct? Did you review that police interview, whether it being video or audio?
I did review all the videos and audios that were provided. I don't have a clear memory of her interview though.
Okay. So you don't recall if you would have reviewed that interview?
Well, I would have reviewed it if it was part of what I received.
You don't recall, and it's not indicated in your report that you reviewed that specific one, correct?
I probably didn't separate them out. On the second page, it says that I reviewed the case-related videos and audio recordings.
Sure. Okay. Let's assume, and as fact, that Ms. Williams did give an interview. She indicated to police that it's possible that Mr. Williams could have smoked something and it had been laced with something. If that fact is considered true, much like the judge was asking you, would that have an effect on your opinion?
If she said that he could have smoked it.
Let's say she did.
Yes, I would definitely want to know more about that. And if indeed he had, that would definitely influence my opinion, because then I'd have to consider the voluntary intoxication.
Sure. And had you known that piece of information, let me back up just a little bit. Did you review all the collateral information prior to your first interview with Mr. Williams?
I reviewed all the discovery, yes. I talked to Ms. Williams afterwards.
Okay, so you reviewed all the videos that you were provided?
Correct.
You reviewed all the police reports?
Yes.
Okay, so you would have had that piece of information as a result of her interview with the police prior to talking to your interview with Mr. Williams?
I would have, yes.
Okay. Yet you did not talk to Mr. Williams about that specific piece of data, did you?
I did. I always ask people if they had been using any substances before or during, and he said he was not.
Okay. You didn't approach the subject of Mom saying that he had or possibly could have?
Correct.
Okay. Why not?
I'm not sure. Like I said, I don't remember the details of the interview with the video or audio interview of Miss Williams.
Okay.
So I can't answer that question.
Okay. Do you think that would have been an important piece of information that should have been reviewed with Mr. Williams?
Certainly, whenever I have conflicting reports or conflicting information, I do like to try to resolve that, yes.
Okay. Okay. And you did say, you told the judge that you had reviewed his video recorded statement with the police, correct?
Yes.
And you watched all of that?
I did.
So you were aware of the fact that he refused the DNA sample prior to your interview with Mr. Williams?
I would have been aware of that, yes.
Okay. Yeah, you did not discuss that piece of data with Mr. Williams either as to why he refused.
I don't remember, and I don't see in my report that I asked him specifically about that.
Let me ask you this. Had you talked to him about that, would that have made it into your report?
Yes, particularly, well, yes.
Okay. So it's safe to assume it's not in your report. You didn't talk to him about it. Is that fair?
That's fair.
Okay. And did you listen to and this one was audio, as you remember, did you listen to the audio interview with the victim in this matter, Dr. Allen Altman, prior to your first meeting with Mr. Williams?
The victim interview, I did, the video, yes, I did review that.
Okay. This one was an audio. It was not a video.
Mm-hmm.
Okay. You did review that.
I did.
You seemed surprised when the judge made mention of Mr. Williams having the hoodie zipped up. Do you know where that piece of information, that piece of data came from?
Not offhand, no.
Okay. If I tell you that it came from the victim interview, is that a fair statement?
I would believe you.
Okay. All right. So again, you should have known that piece of information prior to your going to meet with Mr. Williams.
Yes, I would have heard it as part of the video. Yes.
As part of the audio statement of Dr. Altman, correct?
Correct.
Yet, once again, you didn't talk to Mr. Williams about the fact, which indicated to the judge that you would need more information, which, fair to say, that should come from Mr. Williams, correct?
Yes.
And you did not talk to Mr. Williams about why he had his hoodie zipped up, correct?
No, I didn't ask him specifically about the hoodie.
Okay. Why not?
Well, I would say probably because when I watch videos for the first time, it's kind of to get a broad brush overview, to understand the offense, and maybe it didn't stand out to me as something that was super significant when I first watched it.
Okay, fair enough. And then there was approximately 2 weeks between your first visit with Mr. Williams and your second visit, right?
Yes.
Did you rewatch any of the videos or re-listen to any of the recordings in that 2 week period?
I don't remember if I rewatched anything.
Okay.
And also, just going back to your other question, the offense occurred in February in winter, so perhaps one of the reasons why the fact that the hoodie was zipped up didn't stand out to me as particularly significant was because it was consistent with the weather.
Okay.
It wasn't like the offense occurred in like June and the hoodie was zipped up. That would stand out to me as odd.
Okay, fair. Did you review the surveillance videos?
From the
ring
victim's
camera,
home?
or I don't know if it was a ring, but.
Yes, I do remember the surveillance videos.
Okay. Do you recall what the victims were wearing?
No.
Okay. Do you recall what the neighbor who came over was wearing?
I don't recall. I want to say I don't know. I don't recall. I have a vague memory of the written account as maybe him being in a robe or something, but I don't remember.
Okay, you don't remember. So if I told you they were all wearing like shorts and the neighbor was in a robe, being outside, none of them had on hoodies or jackets, you have no reason to dispute that, correct?
I have no reason to refute that, no.
Okay.
Although they were in their home
Sure.
casually, I'm guessing, so
Sure.
it wouldn't surprise me they
When
were
he
dressed casually.
came in unsuspecting, right?
Correct.
Okay, fair enough. Did you, so you reviewed the video surveillance. As part of that, you must have reviewed the portion that shows Mr. Williams driving towards Miss Eastman and Mr. Rust standing in the driveway and ultimately hitting Mr. Rust, correct?
I do remember that, yes.
Okay. And given that piece, did you consider that piece of data when you told the judge you didn't view him leaving as fleeing the scene? Did you also consider that piece of data that he swerved towards them, hit one of them, as, in your opinion, we'll say, of him not fleeing the scene? Did you take that into consideration?
I certainly considered the fact that he ended up running over the neighbor's foot, and as an indication of, speed or hurriedness. But again, in the context of what reportedly happened in the home, and then his mom saying we need to leave, I put that all together as him leaving in a hectic, erratic, agitated manner. I didn't on the face of it interpret it as fleeing the scene, as if to get away from something intentionally.
Okay. Going back to your collateral information sources, I notice as compared to comparing yours to Dr. Dreyer's, you didn't list Mr. Brenner as a source of information. Did you have a conversation with Mr. Brenner about the case? You don't have to tell me what you said, but I'm just asking, did you contact Mr. Brenner about the case?
I do typically contact defense attorneys about cases. I don't list them as a collateral source of information if I didn't speak to them before I prepared my report.
Okay, so you wouldn't have spoken to Mr. Brenner?
I don't remember if I did.
Let me ask you this. Had you spoken to him, would that have been in your report?
Yes, if I had gotten collateral, I should have, and usually do, put that under my collateral sources.
Okay, just like if you had spoken to me, that should have made it in your report as well.
Yes.
Okay, and we've never spoken about this case, correct?
No.
You didn't try to reach out to me to get information?
No.
Okay. Same thing with the lead detective, Detective Toomey in this case. Had you reached out to him and spoken to him, that should have made it in your report as well.
Definitely.
Okay, but you didn't contact him?
I did not.
Okay, even though by your own testimony a few minutes ago, you said the first time that you watch a video, it's kind of hard to kind of piece things together and find out what happened in the event. Don't you think that he would have been a wonderful source for you to use just to sort of piece things together and understand the events that you're working on?
I do sometimes contact law enforcement directly. However, when the incident reports that we receive in the discovery are well written and detailed, I don't feel as much of a need to reach out to the law enforcement.
I'm sure he'll be happy to know that you consider his report well written and detailed.
Yes.
Okay, fair enough. And you didn't get any medical records from the jail regarding Mr. Williams either, correct?
I did not request medical records from the jail. Typically, if I don't, I want to say, and again, I don't have Dr. Nicking's report, if a previous report includes information like medical records, then I don't request them. So I'm guessing Dr. Nichting probably requested records or had information about his jail presentation.
You're guessing that she did?
I am.
Okay. You don't know for sure.
I don't
Okay.
know.
And that's not something that you independently reviewed, correct?
And that's not what?
Like the records themselves, that's not something that you independently reviewed. You were just relying on whatever Dr. Nichting may or may not have included in her report? Is that a
Correct.
fair statement?
I did not independently request the jail records.
Okay, or review them. I don't want to, we're like splitting hairs here, right? You're saying requesting them. Did Dr. Nichting provide you with the defendant's medical records?
Dr. Nichting did not provide me with the medical records.
Okay.
I don't remember what she may or may not have included in her original competency report.
In her report?
Correct.
Okay.
If there was information from the jail in her competency report, I would have seen it there.
In her report?
Yes.
Not by your own independent review of any medical records?
Correct.
Okay, now we're on the same page.
Yes.
Thank you. Okay. And again, this may be splitting hairs, but I notice in your opinion that you are classifying the defendant as having a severe mental illness and not a severe mental disease, which is the language of the statute, correct?
Okay.
Is there a significance in your use of the word illness versus disease?
No, I would say that's not significant.
Because you would agree with me that there are certain aspects of the law where we are looking for a severe mental illness, such as a death penalty case, correct?
Yes.
Okay. That's not the standard under the law we're looking at here. We're looking at severe mental disease under the statute, correct?
Yes.
Okay.
I would say the fact that mental disease doesn't appear in my opinion section is a function of a typo, because it is referenced like above in issue 4. It is identified as a mental disease in other areas of my report.
Okay, so that's just like an interchange of words. There's really no significance to you using one word as opposed to the others. Am I understanding you correct? I just want to make sure that there's not some distinction that you're making that I'm not picking up on.
No, I'm not making a distinction. No. As far as the statute, yes, severe mental illness, parenthetically disease.
Okay, I just want to make sure we're talking about the same thing.
Mm-hmm.
Okay. Okay. I just want to go through a few things, and the judge has done some of this already, so I'm not going to repeat, but there are some things that were provided in the collateral information that I want to talk to you about. So you're aware, because you reviewed Dr. Altman's statement, that the assault of Dr. Altman by Mr. Williams only started after Dr. Altman was speaking to Mr. Williams' daughter, correct?
After Mr. Williams was speaking to
Mr. Williams entered the home. According to Dr. Altman's statement that you reviewed, Mr. Williams enters the home, shakes his hand, says, "This is mine." Dr. Altman is calm with him, not aggressive, correct?
Correct.
Tries to, "Hey, what's going on here?" kind of thing. And you're aware of the fact that Mr. Williams had his daughter with him, correct?
Yes.
Okay. And Dr. Altman at some point starts talking to the little girl, saying, "Oh, is this your daddy?" Or, just trying to get information about what's happening in his home, correct?
Yes.
And it was only at that point that Mr. Williams started assaulting Dr. Altman.
Correct.
Okay. Did you consider that piece of data in your analysis?
I did. And later put that together when, I'd say connected it to when Mr. Williams left the home and his mother said like she didn't know what was going on, and Mr. Williams said he's a pervert, referring to the victim.
Okay. So did you also consider, and if so, how, the fact that after mom comes in and says we need to go, on his way out, Dr. Altman is still on the ground, that's when he proceeds to kick him in the ribs? How does that piece of data affect your analysis?
So putting it all together as best that I could, it appeared to me that Mr. Williams was experiencing some delusional beliefs. One, that what was in the victim's home was his. Two, that the victim was, for some unknown reason, a pervert. And so those, while it was delusional and psychotic, those two things, like that makes sense to me. If you are under a delusional belief that somebody is a pervert and then they speak to your daughter, it makes sense to me that you might feel some type of way about that and hit them, kick them, whatever.
Okay. Did you ask Mr. Williams about those data points during your interviews?
I do remember asking kind of how it went from relatively benign, like saying, oh, this is mine, to the physical assault. And Mr. Williams was not able to kind of help me understand that. He was able to articulate why it went from benign to violent.
Did you ask him specific points like, why did you hit him? Why did you kick him?
I'd have to look back at my original interview, but I certainly did try to flesh out what was happening and, like I said, why it went from benign to violent.
But you don't recall if you asked him specifics about the incident that you received from the collateral data?
I can't tell you what specific questions I asked. I do remember as I was trying to get specific information from Mr. Williams, that was part of the difficulties because he did not remember specifically what happened.
Let me ask you this, because maybe I'm off base on this. So let's talk about your process when you're interviewing a client.
Yeah.
Do you go in and say, tell me what happened? Or do you try and dissect certain parts, like the questions that I've been asking you? Do you understand my question?
Yes.
Okay.
So my process is to go from big to little, from general to specific, because of course I want to just hear what the defendant remembers and want to hear their account of the story. And then after they've given me all of their account, then I go back in what they've said and I ask clarifying questions. Well, you said this here, can you tell me more about that? Or you said you were experiencing, you said you were hearing voices. Can you tell me about those voices? So yes, I always ask clarifying questions about what they've told me. And then I also ask specific questions relative to the legal question. So I ask things like, was there any point in time where you thought you should stop doing whatever you were doing? Or if there had been a police officer there, would you have still done that? Or did you, like, as you were doing this thing that you were doing, did you have any thoughts or worries about getting in trouble for it? So I also try to tease out what their understanding of the wrongfulness was at the time of the offense.
Okay. And when you ask questions like that, does that make it into your report?
I do try to, yes, when I ask clarifying questions, I will kind of make a list of the questions that I asked and then the answer that the person gave. Other times, like when there's no significant additional information added, or when the defendant can't really elaborate, I will just incorporate whatever they told me into the account of the offense.
Okay. And I'm looking at your report, and as an example, I think you do this on page 4, correct? There's one, that's the one place in your report I see the very top second paragraph says, question, why did you stop when you saw the police officers? Is that an example of what you're saying?
Yes.
Okay. And he said, I figured I'd done something wrong, like ran a red light or had expired tags. Okay. And so he jumped out of the cruiser, saw them draw their guns. I figured I'd get out of the car. So as part of the collateral information that you received, you're aware that prior to this stop at McDonald's, there was a prior police pursuit of Mr. Williams, correct?
Yes.
Okay. And that pursuit was called off by officers because of the child in the car.
Correct.
Okay. Did you ask him why he didn't stop for the police when they were pursuing him at that point?
I don't remember if I asked him that or not.
If that would have been a question you asked, would it have made it in your report in some form, whether it be a question form or in a narrative form?
I'm going to say probably.
Okay. Would you consider that to be an important piece of data that you should be considering in your opinion?
Yes. Why he didn't stop initially? Yes.
During we'll call it the pursuit.
Right.
Yeah,
that's a good question.
Okay. But you didn't ask him that. Or if you did, it didn't make it into your report.
I agree with the second part of what you said.
Okay. Fair enough. You'll agree with me that I'm going to jump back to his interview. Officers, during his interview, Detective Toomey asked him if you recall, his DNA would be in the house. Do you recall that part of the interview?
I don't.
Okay. Well, he asked him, would your DNA be in the house? And Mr. Williams' response was, no, it wouldn't be in the house. Do you recall that?
I don't at this point recall the videos.
Okay. Well, assuming that's true, part of the interview, he then says, Detective Toomey says, would you give me a DNA sample? Mr. Williams says no. Did you consider those data points that I just gave you in writing your opinion, forming your opinion?
So I'm sure that I considered all the things I had watched in the video. In my opinion, I don't know that I necessarily called that specific part out. Although as you recount that interaction, again, acknowledging that I didn't ask about why he didn't provide the DNA sample, it makes sense to me in the context of my understanding of the whole offense. It makes sense to me that if Mr. Williams didn't have memory at that point of having been in the victim's house and done all those things, and then saying his DNA wouldn't be there because he didn't recall that he had been there, it makes sense to me that he would not provide a DNA sample or he would say he wouldn't provide one if he had no reason to believe that there would be DNA there. So I'm saying all that to say, in my mind, there's some consistency between that response and Mr. Williams' mental state at the time.
Okay. Or in the alternative, wouldn't you agree that refusal to provide a DNA sample might be a sign that, yes, I do know the wrongfulness of what I just did, and I don't want to provide additional evidence to the police?
I agree with that, yes.
Okay. Okay. I'm almost done with you, doctor, I promise. You said in your report that the defendant has no history of violence or inappropriate interpersonal interactions, reflecting that he had previously conducted himself in accordance with the law. Behavior he exhibited during the index offenses was contrary to his history of appropriate behavior, which appeared to be in the direct result of his psychiatric symptoms. That's your statement in your report, correct? Which is on page, didn't write the page number down.
It would probably be under the symptoms of mental illness section.
That's my bad for not writing the page.
Oh, it's on page 8.
Page 8. Okay. That's your statement in your report, correct?
Correct.
All right. Would you consider robbery as a violent behavior or some inappropriate interpersonal interaction?
I would.
Okay. And you're aware that the defendant has a robbery that he was adjudicated delinquent on February 1st of 2017 from Franklin County? Are you aware of that?
I don't remember. If it was part of the discovery, then yes, I would have been aware of it. I treat juvenile charges. I don't put them in the same category as adult charges.
So you didn't consider robbery committed as a juvenile as violent behavior?
I mean, of course, I consider robbery as a significant crime.
Knowing that that is out there, does that have an effect on your opinion?
I tend to place more emphasis on a defendant's adult legal history. That's not to say I discount things that happen when they're juveniles, but as far as my statements about their having engaged in law-abiding or not behavior, it's always in terms of their adult legal history.
So if theoretically a juvenile committed a robbery on year 17, day 363, 2 days before he turns 18, and then someone commits a robbery 18 plus a day, you would consider the second scenario, but not the first?
I would certainly consider that in terms of a history of behavior and involvement with the legal system. So, I mean, I take your point. I just, in terms of the evaluations, we tend to only get adult legal history anyway. But
So back to my question then, now that you know that's out there, does that have an effect on your opinion?
the fact that he had a robbery charge as a juvenile does not impact my opinion, no.
Okay, so the behavior that he exhibited during the index offense was contrary to his history of appropriate behavior.
So I could amend that to say, with the exception of the robbery charge as a juvenile, that could be included in there.
Okay, we can move on. You said you glanced at Dr. Dreyer's report. I think the term that you used, or
I read through it
you
once.
read through it? When did you read through it?
Mr. Brenner sent it to me, I want to say Tuesday.
This week?
This week, yes.
So, okay, so-
I read it the same afternoon he sent it to me.
Fair enough. In preparation for this hearing today.
Correct.
Okay.
I will add to that. I typically, I don't put a lot of time into reading other people's reports because my emphasis is on talking about my opinion, so.
Sure. Fair enough. Fair enough. So you may or may not be able to answer this question then if you didn't get too far into her report, but can you explain to me how your process in the forensic evaluation differs from that of Dr. Dreyer?
Having worked alongside Dr. Dreyer at different agencies for several years, I would say I'm familiar with her process only as reflected in her reports. I don't think our process is, in terms of like how we think through a case, is all that different. Dr. Dreyer, when she's, and again, I see most of her work as a second opinion, so I think Dr. Dreyer is, as she's doing a second opinion, is very conscientious about like getting a bunch of records, listening to jail phone calls. Like she's very good at getting a lot of information when she's doing a second opinion. But otherwise, I think our process as forensic psychologists is similar.
Okay, fair enough.
I have a question. What's the difference between the first opinion and the second opinion in terms of the work you do? It should be the same, right?
Yes, it should be the same. I think.
What is it?
The benefit of doing a second opinion is that you you're able to kind of do what you would do, and then you might be thinking of additional things sometimes. Or you also have the benefit of sometimes the defendant recalls more, or you have additional records that you're able to review. And so I think seconds, while the process with the psychologist is the same, seconds can often have additional information that the first opinion did not have.
Okay, go ahead, Ms. Trainer.
Let me ask you this. Had you been the one to do the second in this particular case, would you have done anything differently than you did being the first evaluation?
I wouldn't have done anything differently in terms of my process. To my earlier point, if there had been additional records or information, or if Mr. Williams had recalled more information about the offense, then that would have just been like bonus material for me. But in terms of the process, no, I would not have done anything differently.
You would agree that in this particular case, you had access to the same information that Dr. Dreyer had.
I would say yes, although I didn't memorize Dr. Dreyer's report, so I don't remember if she listed
you
anything
can take a look at it
differently
I
on
think
her
Ms. Kilgore's got
first page.
Exhibit 1, I believe. If you want to take a look at her section on collateral information.
Okay.
And see if there's anything in there that she had access to that you did not.
Ms. Trainer, because the cross-examination is going a little more extensively than I thought. We have the case behind you that as soon as he gets here,
Okay.
Mr. Knott, we're going to go ahead and do that case, which is a
That's
plea.
fine, Judge.
So we'll just take a quick break. We'll do that, and then we will resume.
I literally have 2 more questions for her after this.
So the only things that are different in Dr. Dreyer's report in terms of information that she accessed would be numbers 14, 15, the Warren County medical and mental health records, and then it looks like maybe she had a conversation with Detective Toomey, and then a conversation or information provided from you. Those are the only things that are different.
And you would agree with me that those would have been resources that would have been available to you had you requested it, correct?
Yeah.
Okay. So she had access to nothing that you didn't potentially have access to.
I agree.
Okay. In her report, Dr. Dreyer asked Mr. Williams flat out if he knew the wrongfulness of his behavior. You recall that?
I believe you.
Okay. I will let you know that is in her report. Asked the defendant if he knew the wrongfulness of his behavior. And he responded, I should have. Why did you not ask that question to the defendant?
So I do ask, like I was saying in my earlier testimony, I do ask people or defendants questions specifically related to the question of knowledge of wrongfulness. So I'm sure that I asked him that question in some form or fashion. The limitation, one of the limitations of doing sanities is that it's always retrospective as far as the defendant is concerned. And so by the time people are back in their right mental state, they've gotten mental health treatment, they're on medication, they're no longer actively mentally ill, basically everyone that you ask, every defendant will say, well, yes, I should have known. I see that was, wrong for me to have done. And so I have to be careful about putting stock into what people say, yeah, I should have known that, or gosh, yeah, that was wrong in the present tense, because my focus is on what were you thinking? What were you doing? What did you know? What did you understand at the time of the offense?
Okay. You have your report in front of you, correct? Exhibit 2?
Yeah.
Okay. So while we take a break and Judge does this other case, can you find the part in your report where you asked the defendant that question?
Well, yes, I will.
Thank you.
Are we ready, Mr. McKenna?
It's just right in the form.
All right, this is the case of the state of Ohio versus Eric Knott.
Just stay right here. Sign this right.
Case number 25 CR 42786. Dr. Dry, you can stay there if you want, or whatever is most comfortable for you. We're not going to be using this area of the courtroom.
Oh, okay. Actually,
Whatever's best for you, it doesn't matter to me. All right, present before the court is Mr. Knott, represented by Mr. McKenna. We have Mr. View from the prosecutor's office. We're here today for a pretrial, but it's my understanding the defendant is going to be entering a plea of guilty to 1 count of possession of a weapon while under detention, and that there is going to be a joint recommended sentence of 3 to 4.5 years in prison to be served consecutively to the time that he is already doing being the 20 to life sentence, right?
Yes, sir.
All right, Mr. Knott, how old are you?
42.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
Other than what I just said about the joint sentence, has anybody made any threats, promises, or representations to get you to plead guilty to this charge against your will?
No.
Mr. McKenna, we do have the 2 attachments to the sentencing entry. We're not to that yet, but I'm going to ask you to go over those with Mr. Knott. Mr. Knott, you're going to be entering a plea of guilty to a charge that carries with it an indefinite sentence. It's what we call a Reagan-Toke sentence. You and I talked about this, I believe, just a couple of months ago when I gave you an indefinite sentence back in July.
Yes.
So things haven't changed since then. As often as that statute changes, it hasn't changed in the last month and a half. So we've talked about this already. Are you satisfied that you understand and have been properly notified about the Reagan-Tokes information? Yes. All right. You're going to receive a minimum sentence of 3 years, which is mandatory sentence, and then also the indefinite term will be up to 4.5. You're charged with 1 count of possession of a deadly weapon while under detention. It's a first-degree felony punishable by up to 11 to 16.5 years in prison. Also carries with it a mandatory period of post-release control of anywhere from 2 to 5 years. Your rights really haven't changed that much in a month. You still have the right to make the state of Ohio prove that you're guilty of this beyond a reasonable doubt, either to a jury or to a judge. That would happen at a trial where you would have the right to confront all the witnesses against you, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you're going to plead guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on December the 11th of 2024, that the defendant, while serving an indefinite sentence for aggravated murder, was found to be in possession of an improvised deadly weapon known as a shank.
Anything on those facts?
No, Your Honor.
Mr. Knott, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights that you're giving up by entering a plea?
Yes, I do.
What's your plea?
Guilty.
Based upon plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you've been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence today?
No, Your Honor. No, Your Honor.
We have 0 days of jail time credit and no restitution, right?
That's correct, Judge.
Anything from the state?
Nothing else, Your Honor.
Mr. McKenna?
Judge, he's always respectful and polite. He cooperated with the investigation in prison. He knows what he's doing today. He's happy with the plea. We ask you to impose the suggested sentence.
All right. So, Mr. Knott, as a procedural matter, Mr. McKenna has 2 documents there for you. One is a notification regarding Reagan-Tokes. I can read that to you, or if you're satisfied that you understand and have been notified, we'll just skip on over that.
I understand it.
All right. And the second is with regard to the post-release control. If you're satisfied that you have been notified and understand it, we will go on from that.
Yeah, I'm satisfied.
Anything you want to tell me?
No, sir.
All right, the court is going to impose a 3 to 4.5 year sentence. This is going to be consecutive to the time that you're already doing, because I find that a consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. And I find that you're indigent for the purposes of fines and costs. Mr. Knott, I will tell you this. If you and I see each other again, regardless of how the rest of the case comes out, I want you to know I'm going to impose a fine in your case and the costs. And I'm going to direct the clerk of courts to, and we don't usually do this in Warren County, but we're going to do it in this case if I see you again. And I'm going to go after every nickel that you have in your commissary for the rest of your time that you're in prison. Do you understand that?
I understand.
All right. I do find that you have the right to an appeal in this case. If you don't have the money to hire a lawyer, to obtain a transcript, or to pay the costs, you will be provided to those all those things without charge. Good luck to you.
Thank you, Judge.
Thank you.
Go back on the record in. Do you need a few minutes, Dr. McGee?
No.
Okay. Come on back up. I'll remind you that you're still under oath. I think we're well past the 2 questions that were referenced.
You know,
But
Mr. View
continue.
just said the same thing, Judge, so
2 questions means different things to different people.
it's like 10 minutes is never 10 minutes in the courthouse.
All right, go ahead.
Dr. McGee, were you able to find that question in your report?
I did not find that specific question in my report, but on page 7, second paragraph, I think it looks like I kind of summarized his responses to my follow-up questions, where it says, during each interview session, Mr. Williams appeared mildly frustrated and puzzled about his inability to recall the details of the alleged offense. He repeatedly said he had no idea why he would have engaged in the actions of which he is accused because they were so bizarre, out of context, and uncharacteristic of his behavioral history. As he learned more about the offenses over the last year, Mr. Williams recognized and understood the problematic nature of the offenses, but only in retrospect. So I think that paragraph is meant to capture the difficulty that the defendant had, not just in remembering, but also understanding and making sense of why he would have engaged in these offenses.
Okay, that's your summary, but you would agree with me, you did not ask Mr. Williams, do you know the wrongfulness of your actions like Dr. Dreyer did?
I don't agree with you on that because that's one of the questions that I ask every defendant. I'd have to look at my interview template. That's where I'm typing everything that I say and ask in order to be able to accurately state if I did or did not ask him that question.
So there may be things on your template that did not make it into your report?
Yes.
Okay. Would you consider that particular question an answer? Strike that. You didn't consider that particular question an answer to be significant enough to make it into your report. Obviously, because it's not in there.
Well, in this section that I just read, that was my way of summarizing his manner of responding to several of my clarifying questions that I outlined before that I always ask people. And like I said, he recognized and understood the problematic nature. So that implies that I asked, do you know that what you did was against the law, problematic? And he acknowledged it and recognized it and understood it, but only looking retrospectively, which, like I said before, that's one of the limitations in doing these evaluations when people have gotten well, is that they do recognize it, but only in retrospect.
Okay. So your testimony is that is usually a question in some capacity that you ask.
It is.
Okay. So we're just kind of summing this up to maybe a writing style difference between you and Dr. Dreyer as far as your written report?
Maybe, because if a defendant is unable to give me a clear response to that question, I don't know, like I have to gauge whether or not it'd be helpful to include for the court if the defendant couldn't really tell me, yes, I knew it was wrong, or no one says, no, I didn't. I think it's more helpful to my writing style to kind of summarize a pattern of responding, and rather than always outlining every single response to a question if it's not going to be helpful.
Okay, so is your testimony then that he was not able to provide you with a concise answer to that?
My testimonies will be consistent with the paragraph that I wrote, is that he expressed frustration and puzzlement about this whole situation. And while he recognized that the acts of which he is accused of were problematic, that recognition only occurred in retrospect.
Which is your summary that you wrote because he didn't give you a yes or no clear, concise answer, correct?
Yes.
Okay, thank you. I have no further questions.
Mr. Pryor?
Just very briefly, Your Honor. So, Dr. McGee, you were asked repeatedly by Ms. Tranter about a number of things. So I'll start on, she hit on, the responses that Mr. Williams gave to police where he denied knowing the victim and denied giving a DNA sample. Is that right? She asked you that question?
She did.
Okay. And it appears the state's trying to characterize that as some kind of, him avoiding culpability. Is it fair to say that, your interpretation of those responses would depend on Mr. Williams's mindset in giving those responses?
My interpretation of responses to those questions would depend on what the response was and how he explained or elaborated the context of that response.
Sure. And so it's fair to say that's not, just because that response was given, that's not indicative of something one way or the other without more information.
Correct.
Okay. And I know Ms. Trainer asked you repeatedly, but that paragraph that you hit on page 7 of your report, the last sentence, as he learned more about the offenses over the last year, Mr. Williams recognized and understood the problematic nature of the offenses, but only in retrospect. We can infer from that you did ask him if he understood the wrongfulness of his action, correct?
Correct.
Okay. Your Honor, I have no further questions.
Any number of questions left for the doctor, Ms. Trainer?
Oh, Your Honor.
All right. Thank you, doctor. You can step down.
Yes.
Yeah, we're good. Anything else, Mr. Brenner, on behalf of the defense?
No, Your Honor.
Any rebuttal?
No, Your Honor.
Closings?
Your Honor, I'm not going to say I'm going to be brief because I'm not going to get called out. But I think what this boils down to, Your Honor, is obviously we're down to one prompt. Did the defendant know the wrongfulness of his actions as a result of this mental disease that both doctors agree that he had? In order to have a proper evaluation, the data points have to be considered. The state's opinion is that Dr. Dreyer certainly did that in a more thorough fashion than Dr. McGee. Dr. McGee, when Mr. Brenner asked, what data supports your conclusion that he did not know the wrongfulness of his actions? Her response was his recollection, the video evidence, and his mother. That's it. She was not able to articulate specific instances of data that support that conclusion, contrary to Dr. Dreyer, who says, yesterday, I considered the data that supports my conclusion is that he disguised his appearance. He fled from the police. He refused to give DNA. She was able to cite specific instances that she was made aware of through all the collateral information that was provided. When I asked Dr. McGee about specific points of data, she repeatedly said, I need more information. I need more information. If I had more information, even the court's questions to her, she responded, had I had more information. She did have the opportunity to provide or to have the same information that Dr. Dreyer did. She didn't bother to talk to Mr. Brenner. She didn't bother to talk to me. She didn't bother to talk to the detective. 3 sources, which certainly would have added a lot of information to her evaluation. It seems that Dr. McGee has made the leap, as Dr. Dreyer was suggesting yesterday, that just because he is suffering from this mental disease, then he must not know the wrongfulness. There's no data to support her conclusion, as opposed to Dr. Dreyer, who gave the court multiple instances of data that support her conclusion that he did. With that, Your Honor, and the submitted exhibits, we would ask for a finding of guilty on all charges.
Mr. Brenner?
Thank you, Your Honor. In closing here and in response, I think Dr. Dreyer was able to cite more data points, but I think what we have from Dr. Dreyer are conclusions that were drawn in such a fashion to lead her to those positions, but without the necessary underlying information to make those conclusions. So she's characterizing him having the hoodie zipped up as him concealing his identity. Again, it's February. I think that Dr. McGee today, hinted as much when she was asked about it.
Dr. Dreyer indicating, that Mr. Williams' denial of knowing the victim, denial of being in the house, denial of being in the vehicle, denial of giving a DNA sample are all indicative of him avoiding culpability. When she was asked about that during her testimony yesterday, she admitted that it could be his disorganized or delusional thoughts that lead him to make that conclusion as well. So again, Dr. Dreyer is using these data points and arriving at conclusions that I would argue to this court are up for interpretation. And as Dr. McGee testified to today, entirely depend on the defendant's mindset when he's giving these responses and taking these actions. I think, again, both doctors agree that Mr. Williams was suffering from a mental disease or illness. It sounds like those terms are somewhat interchangeable, and it may have been a typo in Dr. McGee's report at any rate. But as Ms. Tranter indicated, the only disagreement is whether he knew the wrongfulness of his actions. And Your Honor, I think that given the information that we received from both doctors, I think that this court must find Mr. Williams not guilty by reason of insanity. Thank you.
Any rebuttal?
No, Your Honor.
All right, the court finds that with regard to all the counts in the indictment, the state has proven beyond a reasonable doubt all the essential elements of each counts 1 through 7. That being mostly contained in the stipulations. Court further finds that the defense has proven by a preponderance of the evidence that at the time of the offense, Mr. Williams had a severe mental disease, and as a result of this severe mental disease or mental illness, as it's been discussed, he did not know the wrongfulness of his actions. Therefore, I am going to find that the defendant is not guilty by reason of insanity on all of these counts. The court is going to order that the forensic center conduct an evaluation to determine if the defendant is a mentally ill person subject to institutionalization by court order. I do find that there is probable cause to believe that the defendant is subject to hospitalization and that the least restrictive treatment available consistent with public safety and the welfare of the defendant is some sort of hospitalization. So I am going to issue a temporary order of detention. That means, Mr. Williams, you are going to remain in the county jail. Given the way things have been going in the case so far, you are taking your meds, they're making them available to you. I do find that the jail is a suitable facility to house you between now and the time that we have our hearing. Mr. Brenner, usually we have a waiver of the 10-day limitation in which to have this hearing. Is that going to be the case today?
Just a moment, Your Honor.
Sure.
Okay, so as you just indicated, right, under the law, you have the ability to have this hearing within 10 days. However, they need a doctor's evaluation, besides the court just said, that they need to decide if the most appropriate place for you is in a hospital, at home, with under supervision of a doctor, etc. Right? And so they're going to need a couple of weeks to do that. So are you okay with waiting?
Your Honor, we would waive that 10-day period.
All right, it probably shouldn't take the forensic center long, given that they have a history with Mr. Williams to get that, but I know that they can't hit that 10-day mark ever. So we'll get this set. Ms. Idle will be back, thankfully, on Tuesday, and she will schedule the hearing when she gets back. I will take care of drafting the entry, and Ms. Caruco will make sure that it finds its way to the forensic center.
Thank you, sir.
All right, have a good weekend, everybody.
You as well.
Keep you posted. Thank you, Your Honor.
Here's 3 and 4.
I think Judge has.
Mr. Green, Councilor Green, you can go in forward and speak with the city ahead of your client's arrival.
Okay, great. Thank you, Your Honor.
All right, Ariana Patton.
Yes, sir. Good morning.
Yeah, ma'am, are you an officer, Patton?
Yes.
Good morning to you.
Good morning.
You know how to do it. Wonderful.
Today is the 22nd. Oh, okay. All right.
All right, that, Mark,
Yes. Good morning.
you're our attorney? Yeah, good morning to you. Who's your client?
Samuel Gaeke, Gaecke.
All right, your client is in the waiting room. I'm gonna let him in. Go to breakout room 4. I'm gonna put your client in breakout room 6. If your client takes a deal today, make sure your client is fully advised of his rights or rights, all right?
Great. Thank you, Your Honor.
Mr. Gaeke, join breakout room 6. Your attorney is here. He's gonna come see you in a few minutes, all right? All right, let's go back on the record, Mr. Dalan. Mr. Dalan, I've given you an opportunity to speak to counsel. Counsel, what you plan want to do?
Okay.
Waiting for the interpreter.
رجعنا لسيد جيلان. شو قرر يا محامي شو رح يعمل السيد جيلان؟
Your Honor, my client has shown valid insurance and registration. We seek dismissal based on valid documents.
حضرة القاضي الموكلني هو فرجاني على تأمين شرعي وتسجيل السيارة شرعي. رح نطلب منك تلغي القضية لأنه كل شيء شرعي.
All right, case is dismissed. Mr. Dalan, have a very good day and best of luck to you.
سيد جيلان مبروك. لغى القضية وقال لك موفق وإن شاء الله نهار سعيد.
ان شاء الله. ما في دفاع تكتات.
I don't owe anything, right?
No, you don't. Sir.
لا ما سكر الشاشة. اشكرهم.
Thank you so much. Thank you so much. Thank you so much. وهذه فرايدة وشكرا لك. شكرا لك. الله يرضى عليك. تسلموا لي.
God bless you.
ما في بروف. ما بيبعثوا لي بروف.
سكر.
Bye. Bye.
Have a good day, sir.
Thank you so much. Thank you so much. Thank you so much.
Alahami. Hey, Alahami.
Yes, sir.
Oh, you're officer. Okay, good morning to you.
Good morning.
Right. Mr. Hall, I don't know if anybody else needs your services. All right. Shonda Lake.
Yes, I'm here. Good morning.
Good morning to you. City of Detroit versus Shonda Lake, case number C 575022, counts 1 and counts 2, appearing for the left 3.
Elwood S. Mary Jr. on behalf of the defendant. State your full name, Ms. Lake.
LaShonda Lake.
Today is the date and time. It's not. It's set for the 29th. It's the 29th. Do you have valid documents, ma'am?
Yes, right here.
All right, go to the breakout rooms, the purposes of show cause, arraignment counsel.
Yes, Your Honor, we waive the reading of the information and stand mute.
Enter a not guilty plea on your client's behalf and give your client a $0 bond. I'll put you in a breakout room with Mr. Berry, Ms. Lake. Mr. Berry, get Ms. Lake an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay.
And what are the charges, Your Honor?
It's no insurance and no registration.
Thank you.
Join the room, please. Pass the night. Let's go okay, is anyone ready? Attorney Seymour, are you ready?
I am, Your Honor.
This is the city of Detroit versus Jeremy Nathan Link, case number 253554261. Appearance for the record, please.
Seymour Schwartz, Your Honor, appearing on behalf of the defendant who is sitting right next to me. You can see him. Morning. We're requesting a trial, and the discovery is going to be provided to us.
All right, good morning to you, Mr. Link. State your name for the record.
Jeremy Nathan Link.
All right. Come back on the 12th of September at 9 a.m. If there's nothing further, have a very good day and best of luck to you.
Thank you, Your Honor.
You're welcome.
We'll be there.
What is your name, sir?
Lucas.
Nathan.
He's on the first page, Your Honor.
Do you have a cell phone?
He doesn't. It's in the car, sir. It's outside.
Can you go get it?
Yes, sir.
Or just zoom in from outside?
Okay.
Thank you. I'll get you out.
Appreciate it.
Today is Raymond.
I'm back.
Let's go back on the record with Ms. Lake. Ms. Lake, I've given you an opportunity to speak to counsel. Did Mr. Berry come back yet?
I'm back, Your Honor.
I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client has shown valid insurance as well as registration. We seek dismissal.
Case dismissed, ma'am. If there's nothing further, have a very good day. Best of luck to you.
Thank you.
This is the city of Detroit versus Carisha Green, case number SP 172771111. Appearance for the record, please.
Edward S. Berry Jr. on behalf of the defendant. State your full name, Ms. Green.
Carisha Green.
Carisha Green, I'm sorry, ma'am. Today is the date and time set for arraignment. Go ahead, purposes of arraignment, counsel.
Yes, Your Honor. We would waive the reading of the information and stand mute.
Enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Ms. Green, I'm going to put you in a breakout room with Mr. Berry, have a conversation with him. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay, thank you.
Join the room, please. Let's pass for now.
She's not on today, sir.
She is a Raymond on the bench, Raymond at 8:30. Let's go back on the record with Mr. Owensby. Mr. Owensby, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Judge, we're going to move for dismissal based on valid documentation.
Case dismissed, Mr. Owensby. If there's nothing further, have a very good day. Best of luck to you.
Thank you, sir. Have a good day.
You're welcome.
Judge, said I have one case for 2, 3.
Oh. City of Detroit versus Joel Green, case number SP 172744661, SP 172764041. Mr. Zoran, can you put your appearance on the record, please?
Bob Zaranick for the defendant. Please state your name, sir.
Hello.
Joel Nathan Green.
Say Joel Green.
You have Joe Green there. Can you start your camera, please?
Oh, yes, my bad.
All right, good morning to you, sir. State your name for the record, please.
Good morning, Joel Green.
All right, Mr. Green, the date is the date and time set for a retrial. Mr. Green, I'm gonna put you in a breakout room with Mr. Zoranic. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to the trial, okay?
Okay.
I don't see him on the, Joe Green.
He's at the bottom of 835, last name.
No, I know, I don't see him on there. I don't see him on here to place him in the breakout room. Oh, here. Is that Harry Bachman's client? That's Harry Bachman's client. Let's pass the matter. We'll wait on Mr. Bachman. All right, is this on the iPhone that just checked in? What is your name, please? Unmute yourself on the iPhone.
My name Ladia Oni. My phone had died, sir.
All right. On the iPhone, I just let in the room iPhone 3. Good morning to you. What is your name, please?
Good morning, Your Honor. This is Nathan Lucas.
All right, City of Detroit, good morning, versus Nathan Daniel Lucas, case number SP 160684961, SP 111617, counts 1, 2, and 3, SP 11116371, SP 112980, strike that, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 96449661, 22737166, counts 1 and counts 2. Appearance for the record, please, Mr. Zoranic.
Bob Zaranick for the defendant. Please state your name.
Nathan Daniel Lucas.
All right, today is the date and time set for arraignment on the bench warrant, counsel.
And so, warrant judge, we waive the reading of the, waive the formal reading, stand mute. We're asking that the warrants be set aside.
We are not good to benefit have to call warrants, and he owes $336 on an old no insurance proof. If he pays that, he owes 2 other civil infractions to a defective lights 192 and a registration 174. If he pays the old no insurance proof, he can potentially set himself up to get a valid driver's license. I'm gonna put you in a breakout room, sir, with Mr. Zoranic. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Right?
Thank you, sir.
Join the room, let's pass the matter. Are you, your client is here, Nolan Gresens.
Great, thank you, Your Honor. I've been communicating with him by text message.
Are you ready on Mr. Gresens?
Yes, Your Honor.
City of Detroit versus Nolan Gresens, case number SP 175-4770, counts 1 and counts 2, SP 175-5172-1, SP 175-5173-1, 09.
So send me what you
You have to mute yourself, Officer Thomas. Z8 097461, appearance for the record, please.
Thank you, Your Honor. Vince Green on behalf of the defendant, Nolan Gresens.
All right, Mr. Gresham, good morning to you. State your name for the record, please.
Good morning, Your Honor. My name is Nolan Gresens.
All right, good morning. Today is the date and time set for a pretrial, and then we're gonna pre-try the other. You've already pre-tried the Zeke ticket as well, right, Counsel?
That is correct, Your Honor.
All right, for the purposes of bond, we're gonna give your client a $500 personal bond. We're gonna have your client test 1 time per week. The client is not allowed to leave the state without the court's permission. And obviously, no drinking during the pendency of this case. I need a good phone number from your client.
Go ahead, Mr. Gresens.
Your Honor, it's 248-251-7766.
Okay, Mr. Gresens, probation is going to reach out to you for the purposes of testing. I expect to see a test here 1 time per week. I understand the day is Friday, so it may not happen that quickly, but if by next week, I want to see a test 1 time per week and every week until the bond conditions change or the case is resolved or some other action happens. I'm going to give you the number to probation just in case. You shouldn't have to call them. They should call you. But that number is 313. 313-965-3414. If you do not hear from probation sometime next week and it gets to be later in the week, then you need to either reach out to your attorney, reach out to the court, and you can always call that number. Your client the testing is going to be if there is a mistest, a diluted test, or if there's a positive test for alcohol, we're going to up the ante on the bond, and your attorney will explain that to you if you don't. That is not a self-explanatory. All right.
Okay, Your Honor.
Mr. Green, what does your client want a pretrial date?
Yes, Your Honor. I did talk to the city attorney. We're getting discovery, and so maybe if we could get another pretrial date, that would be great.
June the 5th. Let me strike that. September the 5th, 2025. Does that comport with your schedule, Counsel?
If by Zoom it does, Your Honor, I'll be in Colorado out there for a celebration, but I can still make that work.
All right, it's by Zoom. It's like Burger King, Counselor. You have it your way.
Yeah, that'd be fine, Your Honor. September 5th.
All right. 8:30 a.m. If it's nothing further, Mr. Gresham, I wish you have a very good rest of your day, and Counselor, have a good day.
Great, thank you, Your Honor.
Thank you, Your Honor.
Mr. Gresens, I'll call you later.
Sounds good.
Okay, let's. Are we ready on Gar? Octavia Gar?
Yes, Your Honor.
Let's go back on the record with Ms. Garth. Ms. Garth, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, she's requesting a bench trial date.
All right, is that what you want to do, Ms. Garth?
Yes, sir.
All right, September the 12th, 2025 at 9 a.m., ma'am. If there's nothing further, I wish you the best of luck. Have a very good rest of your day, okay?
You too.
All right, thanks. All right. Mr. Honor. Yes.
Daniel, I've retained on Roosevelt Outlaw. We are ready on that when you are.
Okay, thank you. All right, Mr. Oni, are you there?
Yes, sir.
All right, City of Detroit versus Liddell Deshawn Oni, case numbers SP 1604589, counts 1 and 2. SP 1630197, counts 1 and counts 2. SP 1696941, counts 1 and counts 2. SP 1696961, and counts 2 and counts 3. SP 1706102, counts 2 and 3. SP 1706122, counts 1 and counts 2. SP 1758513, counts 1, 2, and 3. SP 1768349, counts 1 and 2. Run his license, please. Appearance for the record, please.
Your Honor, Pauline Soroki on behalf of Mr. Oni.
Mr. Oni.
Sir,
State your name for the record, please.
Liddell Oni.
Before you date the time set for retrial. Got some more tickets, so purposes of arraignment on those other tickets, Ms. Soroki.
Your Honor, wait the phone. We're reading the information. Stand mute to the charges.
I will enter a not guilty plea on Mr. Oni's behalf with a $0 bond. Mr. Oni does have a valid driver's license. Congratulations, Mr. Oni.
Thank you.
Accountable for all the mistakes.
Ms. Soroki, are you ready?
Yes.
So I'm 14 into the record.
We'll see what Bolton had in his possession.
Right, and I counted 19 into the record. They are 14 on the docket. So we're looking at a unregistered, untitled, no insurance, another unregistered, untitled, another no insurance, and a drove while license suspended. Give Mr. Oni an updated offer. Keep in mind, Mr. Oni, if you don't like the offer, you have an absolute right to the trial, all right? Put you in a breakout, Mr. Roki. Let us know what you want to do when you come out.
Okay, thank you.
You're welcome.
Your Honor, this is Mark Corvo, back out of the breakout room and ready to proceed for Mr. Sam Gakey.
I think that's ridiculous because that's what we saw in the budget.
Judge, did you mute?
No, I didn't.
Oh, okay.
City of Detroit versus Roosevelt and the state of the City of Detroit. Not the state of Michigan. City of Detroit versus Roosevelt Outlaw, case number SP 1714392, counts 1, 2, and 3. Appearance for the record, please.
Your Honor, Trevor Daniel on behalf of Roosevelt Outlaw.
Okay.
All right, where's Corvo's case?
Your Honor, you may have mentioned my name, Mark Corvo, Sam Gakey. Had a chance to speak to the prosecutor and ready to relay the outcome of that if guided.
All right, now, Mr. Daniel, Attorney Daniel, good morning to you.
Good morning.
Past Outlaw. Now it seems like Mr. Soroki was representing him. I don't know, Mr.
I believe I just filed an appearance on it yesterday, so it may not have processed yet.
All right.
That's fine. You can substitute into the case.
And what is Gakey set for?
Your Honor, that's sent for a bench trial today. I have spoken to the prosecutor, and the case will be dismissed for lack of recollection.
That's the one officer. City of Detroit versus Samuel Frederick Gakey, case number SP 173363331. Appearance for the record, please.
Good morning. Good morning, Your Honor. Mark Corva on behalf of Mr. Samuel Gakey.
All right. Good morning to you, Officer Mr. Gakey. Can you state your name for the record, please?
Judge, it looks like he's in breakout room 6.
Thank you.
Want me to get him back?
I tried to.
Oh, here he comes.
Mr. Gakey, good morning to you. Can you state your name, please, for the record?
Samuel Gakey.
Good morning to you. The day and time set for a trial. Officer did call early this morning, so he appeared, or she appeared, and indicated that they had no recollection. Go ahead, counsel. Counsel, is your motion?
Yep, my apologies, Your Honor. On behalf of my client, Sam Gakey, will put forth a motion to dismiss.
All right, motion is granted. No recollection. If there's nothing further, have a very good day and best of luck to you both.
Thank you. Thank you, Your Honor.
Thank you, Your Honor.
Where's welcome? Where's Outlaw? Outlaw here.
Scheduled for trial today. And we have.
What's going to happen?
Yes, we have spoken with the prosecutor, and they will dismiss 2 of the charges and will plead responsible.
Hold on. Back on the record, let's go call the City of Detroit versus Roosevelt Outlaw Jr. Case number SB 171-4392, counts 1, 2, and 3. Appearance for the record, please.
Thank you, Your Honor. Trevor Daniel, P73480 on behalf of Roosevelt Outlaw, who's present on Zoom.
Mr. Outlaw, good morning to you. State your name, please, for the record.
Good morning, Roosevelt Outlaw.
All right, today is the date and time set for a trial. Is Officer Thomas here?
Yes.
Janelle Thomas, can you state your name, badge number, and department for the record, please? Go ahead, Counselor. What's the offer?
Thank you. The offer is to plead responsible to passenger not wearing a seatbelt and dismiss the remaining charges.
Stipulate to the face of the ticket as an accurate factual basis for that response. Client's behalf, stipulate the proper clause of the dismissal of the other matter.
Yes.
Citing client responsible, as charged for the seatbelt ticket, $65. When can you pay it, Mr. Outlaw?
I can pay that today.
All right, pay it, make sure you get it in here by, let's say Monday. The 25th, all right? Pay it in DivDat kiosk in the City of Detroit. I'm told you can upload the DivDat app to your phone, or you can come down to the courthouse and pay it. There's other ways to pay it. Those are just the 2 best ways to pay it, Mr. Outlaw. If there's something further, you have a very good day, and Counsel Daniel, you have a very good day as well. That's what you want.
Thank you. You as well, Your Honor.
You too.
So let's see if Mr. Soroki, you have any, all right, so everybody's, let's go back.
I'm here, Your Honor.
Okay, who do you have, Mr. Soroki?
We had Diammani lately, and I interrupted you because there's no police officer. I had just talked to the prosecutor, and so we can call that now. That's 9:32. Scheduled for 9 o'clock. Trial.
This is City of Detroit versus Diammani Del Rico lately, case number SP 169-55681. Appearance in record, please.
Alan Soroki, P37441, appearing on behalf of the defendant. What's your name for the record, sir? Please state your name.
Diammani Del Rico lately.
You wanted to serve today's date and time set for a trial. Is there an officer? Obviously, there's no officer.
Perry.
Perry, an officer Perry, go ahead, Counsel. Go ahead, make your motion, Counsel.
Alan Soroki, defense moves to dismiss this matter, Your Honor.
Case dismissed, Mr. Lately, no officer, if something further. Have a very good day and best of luck to you, all right?
Thank you. Have a good day, Your Honor, and good day to your staff.
Thank you, Your Honor. Have a good one.
You as well. Sorry. On record, Ms. Green. Ms. Green, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do? Mr. Barrett, Mr. Barrett. I think your client wants to appoint an attorney.
That is correct, Your Honor. Thank you.
Green, is that what you want? Where's Ms. Green?
She's here in the courtroom.
Yes.
All right, Ms. Green, good morning. All right, you want to appoint an attorney. What I'm going to do is it's 313-706-8985, the best number to reach you?
Yes.
I'm gonna set you a pretrial date for September the 5th, 2025, at 8:30. That date is set just to make sure that that attorney has contacted you. If the attorney has not contacted you, then we'll get one appointed to you on the spot, all right? On that, on that date. I need you to answer the calls you don't recognize. One of those calls should be that appointed attorney. If you don't have anything further, Mr. Green, I wish you the best of luck and have a very good rest of your day, okay?
Okay, so I will have court on the 5th?
You'll have court on the 5th.
At 8:30, okay, thanks.
Best of luck to you, ma'am.
Thank you.
This is the City of Detroit versus Marcel Glover, case number SP 175-3624, counts 1, 2, and 3. SP 175-3627, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Glover.
Marcel James Glover.
All right, good morning to you, sir. Today is the date and time set for a pre-trial. Mr. Glover, I'm going to put you in a breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out, okay? Let's pass the matter. Let's go back on the record with Mr. Lucas, Nathan Lucas. Mr. Lucas, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Judge, we have a plea worked out.
Mr. Lucas, you don't want to try to get a driver's license first?
Well, I discussed it with my counsel, and I think it'll be smarter just to pay this off because there's still a chance of it being held up. Even if I do go pay the insurance ticket and come back to court, there's still one more insurance ticket that can hold my license up. So that's what we just discussed. So I would rather plea out.
Raise your right hand, please. Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yep. Yes, sir.
You can put your hand down. You understand the maximum possible penalty for these offenses are 93 days in jail and or $500 in fines?
Yes, sir.
You understand that you have an absolute right to a trial?
Yes, sir.
Mr. Saranic went over your other advice or rights in the breakout room, did he not?
Yes, sir.
You understood those rights?
Yes, sir.
Do you have any questions about those rights?
No, Your Honor.
Do you know by taking the deal, you're going to give those rights up?
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
All right, what's the deal, Mr. Zarani?
On ticket ending 8102, Judge, which is an improper plate, he'll plead as charged. Ticket 5651 is allowing unlicensed driver to drive. That'll be a 3-month delayed sentence. Ticket 5652 is no registration. A plea is charged. 5653 is a no insurance misdemeanor. Plead that down to improper plates. And 4961 is an improper license. That'll plead to a failure to display. All other matters will be dismissed. So he'll plead to the 5, Judge. 8 will be dismissed.
I'll take the deal, sir. Going to take the deal, Mr. Lucas?
Yes, Your Honor.
Let me draw your attention back to September the 13th, 2022, at around 11:12 p.m. in the city of Detroit, in the area of St. Louis Street and East Outer Drive. Do you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes, sir.
Were you operating a motor? Well, did you own a 2005 Chrysler on that day?
Yes, sir.
Well, on that day, were you operating this motor vehicle or somebody else operating this motor vehicle?
I can't really remember. That might have been the time where somebody else was operating it. I think it was my little brother. He was unlicensed.
So why did you say you were?
Because one of them times I was operating it, sir. It's been so long. I'm not too sure which one of them was that exact incident.
This is allowing an unlicensed driver to drive. So was at St. Louis and Outer Drive? Well, then you probably wouldn't know the date unless you were in the car with him. You own a 2005 Chevrolet Chrysler on that day, didn't you?
Yes, sir.
And you allowed somebody to drive that Chrysler?
Yes, Your Honor.
And you allowed that person to drive that Chrysler knowing that that person didn't have a valid driver's license. Is that correct?
Yes, Your Honor.
I find your client guilty as charged to the allowing. Did you have insurance on that car on that day?
No, sir.
Did you have registration? Was that car properly registered on that day?
Yes, sir.
All right, so we can't take the plea for the no registration. I'm sure we can find another ticket here. All right, I'm gonna find him guilty of the admitted count of improper plate for no insurance. Let me draw your attention way back to September the 5th, 2020, at around 6:16 p.m. in the area of Davison and 6 Mile. On that date and time, did you have contact with the Detroit Police Department?
Yes, sir.
Are you operating motor vehicles?
Yes, Your Honor.
And did the officer ask you to produce valid? Was it something wrong with the plates on that car?
I just bought the car and the officer was unable to see the plate. It was in the window. And I did get pulled over.
All right, well, was it something wrong with the plate? Because the officer's saying that was something wrong with the plate.
Yes, sir. I can take the off. I don't know what was wrong with the plate, sir, but yes, sir.
You see what's going on here? It's either one, he actually doesn't know what's going on, or two, there's a lack of, he's not admitting culpability. This is the problem. I understand these tickets are super old. That's why I asked you, sir, you want to try to go get a license and do this. Let's, what about, so you just bought the car. Did you have insurance on the vehicle?
No, sir.
All right. So I'll find him guilty of the amended count of improper plate for the no insurance. And, did you have a license at that time?
No, sir.
I'll find him guilty of the amended count of failure to display. And you're saying the plates were good, right?
Your Honor, I just purchased the car a week prior. The officer said the plates weren't good, sir. So I'm going with the officer's word. I would like to get this taken care of, sir. I don't want to make anything harder.
Why are you going with the officer's word? You just bought the car.
Yes, sir. I bought it a week prior to when I got pulled over, and they were.
So you don't know whether the plates are good on the vehicle or not?
It was a paper plate, sir.
I don't care what kind of plate it was. You bought the vehicle, right?
Yes, sir.
Where did you get the vehicle from?
I bought it from a coworker.
So did you put the paper plate on the vehicle, or?
No, it was already on there, sir. It was already on there, sir.
So you didn't transfer the vehicle in your name?
I did. It took about a week later. I went up there to transfer the car in my name and get the title in my name. I did not do it immediately.
Stop. Did you do the transfer of the title before or after you got the ticket?
After, sir.
After you got the ticket. So you do know that plate is not any good.
Yes, sir. Yes. If
what?
Well, he was driving the car prior to me buying it, sir. So
You told me that you bought the car.
Yes, sir.
You got the car, and then you transferred the plate, and then transfer. Wait a minute, stop.
Okay.
Listen to me. You told me you bought the car, and a week later you went to the Secretary of State and transferred the plate. And then after that, you said you got pulled over, right?
No, I got pulled over before that, sir.
Okay,
before I got the plates transferred.
So
before I got the car in my name, I got pulled over, sir. I'm sorry for the misunderstanding.
I'm going to set a trial date because this is all convoluted now. Because he can't write you for a no insurance misdemeanor for a car that you say you don't own yet, because you don't own it until you go into the Secretary of State and transfer that plate into your name. So you're not responsible for having insurance on a vehicle. You're responsible for showing proof of insurance, but he can't write you for that misdemeanor. The plate is, whether the plate is improper or not, I don't know. And then I don't know of any other tickets here that we can take a factual basis for. Let me draw your attention back to 11/12/2020 at 11:14 p.m. in the city of Detroit, in the area of Van Dyke and Brucedale. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes, sir.
Are you operating a motor vehicle?
Yes, sir.
The same 2005 Chrysler. Now,
yes.
Are you going to tell me?
Yes, sir.
Yeah, I didn't even ask you a question yet.
Oh, you said the same 2005 Chrysler, sir.
Yeah. Did you have a license on that day?
No, sir.
Found guilty of allowing. Was there something wrong with the plates on that vehicle on that day?
I can't remember, sir.
This is your client, Mr. Zoranek. I don't know.
Was the car registered properly or not then, sir?
Oh, no,
Was
sir.
it registered in your name on that day?
No, sir.
He's sitting in the driver's seat of a car now?
Yes, sir.
Found guilty as charged to the improper plate. So 1, 2, 3, 4, 5 counts of either allowing improper plate or the failure to display. Stipulate the proper cause will dismiss the other matters. All right, I'll fine you for 3 of them, sir. 240, 240, and 240. I won't fine you for the other 2. When can you pay?
I can make a payment today, sir. I'll go in there and pay $300 today, and then the rest of it, if you would allow me a little bit of time, 30 or 60 days to pay the rest.
You see this, Mr. Zaranek? I just don't understand the logic of Mr. Lucas's how he explained it to me. I'm giving the man time to try to get a valid driver's license. He could have paid the $336 today, and then he could have gone and taken care of the other. Now you're going to ask me for some more time, 2 months to pay.
No, I didn't. No, I didn't know that, sir. I'm sorry.
Yeah, you want to get it over with. That's what you want to do. That's what you said.
Yes, sir. If you want me to pay the $360 today,
I'm not going to. No, we're not. Yeah, but now allow payment plan. What I'm going to do is I'm going to give you 30 days to figure it out. Come back on on September 19, 2025 at 8:25. I'm marking the file allow payment plan. And when we get this in the system, you can go ahead and make whatever payment you want. If you want to get into a payment plan, you'll be able to do that. I'm going to waive the warranty. You'll pay the reinstatement fee. If there's something further, Mr. Lucas, I wish you the best of luck. Have a very good rest of your day. You can come up and get your paperwork, and then we will we'll let you go down there and pay whatever you need to pay. All right.
Okay. Thank you.
All right. You're welcome. All right. This is the City of Detroit, Mr. Zaranek versus James Lowell Gordon, case number SP 173-09801. SP 176-3721, SP 176-327, strike that. SP 176-3722, counts 1, 2, and 3. Appearance for the record, please.
Bob Zaranek for the dependent. Please state your name.
He's in the breakout. This must be somebody else's client. They put some writing on behind that. Mr. Gordon, good morning to you. State your name for the record, please.
James Gordon.
Is this James Lowell Gordon?
Yes.
Good morning to you. Did you speak to someone already? You put an attorney already?
Yes. Mr. Bossman or Bossman? I don't know where he is.
Let's pass the matter to Mr. Bossman gets ready. All right. M. Gardner, good morning to you. M. Gardner.
Hi.
Good morning, ma'am. Can you give me the pronunciation of your first name, please?
Miani.
Miani? All right,
Yeah.
good morning to you.
Good morning.
City of Detroit. That's City of Detroit versus Miani Chardonnay Gardner. Case number SP 1729011. Counts 1, 2, and 3. SP 1729031. SP 1745363. Counts 1 and counts 2. Appearance for the record, please.
Bob Zaranek for Ms. Gardner. Please state your name.
Miani Gardner.
All right, good morning to you, ma'am. Today is the date and time set for a set for Mr. Ryan.
I'm trying to find it on the docket, Judge.
Give me 1 second. Let me pass it 1 second. All right.
You don't have to go to the courtroom.
I don't.
Might be under Monet. What's your middle name, ma'am?
I saw that, but I think she was on here for yesterday.
Yeah, because I don't know who.
Chardonnay.
Yesterday.
What's your middle name, ma'am? Miss Gardner?
Chardonnay.
Chardonnay. She was
Okay.
scheduled for 21.
Oh, okay.
I was scheduled for yesterday.
Correct. It's in process, but they haven't got to it yet. They're working on it. She could have just. You cannot take it. Two platters is
All right, sorry about the delay. Miss Gardner, what is she set for?
Judge, it was up yesterday. Not sure.
That's why I don't see. All right, let's go back on the record with Miss Gardner. So she's got an unregistered, untitled, no insurance, improper plate, seatbelt, transporting marijuana, and open alcohol on a motor vehicle passenger. You get that, Mr. Zarani?
Trying to keep up. I got no registration, title, improper plate, marijuana, open alcohol.
Seatbelt. So unregistered, untitled, no insurance, improper plate, seatbelt, transport marijuana, and an open alcohol on a motor vehicle passenger.
Okay. Got it.
How many set for yesterday? It was set for pretrial. We'll call the date and time set for pretrial. Mr. Gardner, I'm gonna put you in the breakout room with Mr. Zarani. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Can you get it?
Okay, thank you, Your Honor.
Join the room. Let us know what you want to do when you come out. All right, let's go back on the record with Mr. Marcel Glover. Mr. Glover, I'm giving you an opportunity to speak to counsel. Counsel, what you want to do?
Your Honor, if the court could confirm Mr. Glover's valid license.
Let's pass the matter. Let's go back on the record with Mr. Oni. Mr. Oni, I've given you an opportunity to speak to counsel. Counsel, your client wants a trial date?
Yes, Your Honor.
Mr. Oni, I'm going to give you a trial date for September the 12th, 2025 at 9 a.m. If it's nothing further, Mr. Oni, have a very good day and best of luck to you, okay?
You too, sir. Thank you.
Thank you. This is the city of Detroit versus Pablo Gomez, case number SP174-979. 1-2, appearing for the record, please.
Your Honor, Pauline Stroke of Mr. Gomez.
Hello.
Mr. Gomez, state your name for the record, please. Good morning to you. Mr. Gomez, state your name for the record, please.
Yeah. Mi nombre es Pablo Gómez.
That's the CTOS interpreter.
Hello, I'm here next to him, helping him.
I gotta get a court appointed interpreter, court authorized interpreter, ma'am. Good morning to you.
Okay.
All right, we'll pass the matter until we get that interpreter.
Okay.
All right, Mr. License is valid for Mr. Glover.
Thank you, Your Honor.
Hold on a second, Mr. Barry. I gotta put this stuff in. Give a minute. Dennis Ventura, are you there? Mark, you're gonna have to mute your background, Mr. Glover, when I call your name. You have too much background noise going on. Ventura?
Yes, sir.
Good morning to you.
Good morning.
City of Detroit versus Dennis Alexander Ventura. Case numbers is more than meets the eye here, Ms. Soroka. Case numbers SP 1177259, counts 1 and counts 2. SP 1221905, counts 1, 2, and 3. SP 1290240, counts 1 and counts 2. SP 129 and count 3, I'm sorry. SP 1377410, counts 1, 2, and 3. SP 1747708, counts 1, 2, and 3. SP 1747709. State of Michigan versus Dennis Ventura, case number SX 419585, counts 1 and counts 2. Appearance for the record, please.
Your Honor, Pauline Soroki on behalf of Mr. Ventura.
Mr. Ventura, state your name for the record, please.
Dennis Ventura.
Okay, what the best thing to do with this case is probably send him to his alphabet judge, because there are so many cases. I'm going to enter a not guilty plea on his behalf. I'm going to give him a $0 bond. I'm going to recall the warrants. You don't have the files from all these other cases. So I'm going to send you to your alphabet judge, who is Judge Williams, Larry Williams. I'm going to give you a pretrial date for September the 3rd, 2025 at 8:35, okay?
Okay.
He owes 336 on one no insurance proof. And he owes some other civil infractions as well, but if he pays that no insurance proof, 336, he can potentially set himself up to get a valid license. You want to speak to him anyway, Ms. Soroki, or you okay?
Yeah, let me let him know that.
All right, go in the breakout room, sir. Speak to Ms. Soroki, and if you don't have any further questions of the court, you're free to leave after you talk to Ms. Soroki, all right? Let's pass the matter. Okay, let's go back on the record with Mr. Marcel Glover. Mr. Glover, I've given you an opportunity to speak to counsel. Counsel, Mr. Glover has a valid driver's license.
Yes, Your Honor. And Mr. Glover would avail himself of the people's offer to enter a plea as charged to the seatbelt charge, the remaining matters to be dismissed.
Want to take the deal, Mr. Glover?
Yes, Your Honor.
I stipulate to the face of the ticket as an accurate factual basis for that responsible plea your client you have.
So stipulated, Your Honor.
Stipulate the probable cause for the dismissal of the other matters.
Yes, Your Honor. So stipulated.
Find the client responsible for the amended count as charged to the seatbelt ticket. Dismiss the other matters for providing valid documentation. Mr. Glover, $65, when can you pay?
Your Honor.
Say what?
Oh, Your Honor, I can pay.
When can you pay it? He just, every time you say the date or say you go silent.
Let me take it off. Can you hear me?
I can hear you. Every time it does it, because there's something going, that it's tricking us.
Pay today.
Okay, pay it by Monday, 2025. And pay it in any div that kiosk in the city of Detroit. I'm told you can upload the div that app to your phone, or you come on down to the courthouse and pay it in person. There are other ways to pay it, but those are just the two best ways I get people to pay it. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day, all right?
Great weekend.
You as well. This is the city of Detroit, Mr. Berry versus Olympia Gravit. Case number SP 1728250, counts 1 and counts 2. SP 1728251, counts 1 and counts 2. SP 1728252, counts 1, 2, and 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Gravit.
Olympia Gravit.
Good morning to you, ma'am. Today is the date and time set for pretrial. Mr. Berry is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. We'll put you in a breakout room with them. You let us know what you want to do.
I had already talked to my attorney Boffman. He said we was doing just a trial.
All right, I'll let them know. Trial day. Where's Mr. Boffman? Mr. Boffman appears for the record.
Good morning, Your Honor. Harry Boffman, P55052 for the defendant. Ma'am, your name?
Olympia Gravit.
Judge, my client's been advised we're requesting a bench trial by way of Zoom.
All right, I'll give her a trial date for September the 12th, 2025 at 9 a.m. If there's something further, Ms. Gravit, have a very good day. Best of luck to you.
Judge, I can't take September 12th. I am going to be out of town.
What day will you be available, Mr.
I'll be back on September 19th. Or no, the 20th.
Well, that's not going to help us. When will you be leaving for out of town?
I'm leaving on the 11th.
That's not going to help us too. Can we do 9/9? Let's do 9/9. 9/9. September 9th. September 9th, Ms. Gravit. September 9th, okay?
Okay.
Best of luck to you, ma'am. Mr. Boffman?
Yes, Your Honor.
Let's go recall the city of Detroit. Is that James Lowell Gordon that you have as well?
Ready.
Let's go back on the record with James Lowell Gordon. Mr. Boffman, can you put your appearance on the record for Mr. Gordon?
Harry Boffman on behalf of the defendant, sir. We are asking respectfully that you set this matter for a bench trial on September 9.
All right, that trial date is September 9th, Mr. Gordon. If there's nothing further, have a very good day. Best of luck to you.
You too. Thank you, Your Honor.
Bashard Gray, are you driving? You're driving. I'm going to put you out, sir, until you get to your safe location. Until you get to a safe location.
I'm ready.
You're driving, sir.
I will get on the passenger side or get out the car, Your Honor.
All right. Let's go with Mr. Berry. You still need someone?
Yes, Your Honor.
And Ms. Soroki, you need someone as well, right?
Correct.
Mr. Berry.
Judge, what was Mr. Gordon's name?
James Lowell Gordon. City of Detroit versus Magdit Abdul Salam Gahar. Case number SP 1752797, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, sir.
Yes, Majid Abdul Saleh Jawhar.
All right, good morning to you, sir. Day is date and time set for a pre-trial. Mr. Berry, give Mr. Gahar updated offer. Keep in mind, if you don't like the offer, Mr. Gahar, you have an absolute right to a trial. I'm gonna put you in a breakout room. Let us know what you want to do when you come out, okay?
Okay.
Join the room, let's pass the matter.
Mike, about counsel, like you saying, I want your assurance that you could be locked away before your inspection. So, probably get locked in.
City of Detroit versus Roger William Lewis, case number SP 1649646, counts 1 and counts 2. SP 1649684-1. SP 1722694, counts 1 and counts 2. SP 1722734, counts 1, 2, and 3. Appearance for the record, please.
Your Honor, Pauline Soroki on behalf of Mr. Lewis.
Mr. Lewis, good morning to you. State your name for the record, please.
Good morning, Roger William Lewis.
Day is date and time set for a pre-trial in the matter. Ms. Soroki, give Mr. Lewis an updated offer. Keep in mind, if you don't like the offer, Mr. Lewis, you have an absolute right to a trial. I'm going to put you in a breakout room with Ms. Soroki. Let us know what you want to do when you come out, okay? Join the room, let's pass the matter. Mr. Hoffman, do you have anyone else?
I do, Your Honor. I'm here also for Joel Green. Did we call Mr. Gordon? James Gordon, are you here?
Yeah, he left. We set him the trial date. Let's go back on. Let's call the City of Detroit versus Joel Green. Case number SP 1727446-1, SP 1727604-1. Appearance for the record, please.
May it please the court, Harry Boffman, P55052, on behalf of the defendant. Would you, sir, state your name?
Joel Green.
Judge, there's a genuine and material issue of fact such that we're asking for a trial date. My client's been advised and wishes to waive his right to a jury trial and have a bench trial on that date and time, please.
All right, Mr. Green, I'm going to set a trial date for you on September the 9th, 2025 at 9 a.m. There's nothing further, sir. I wish you the best of luck. Have a very good rest of your day.
Thank you, Your Honor. Have a great day.
Stuff in for this gentleman, Mr. Lewis.
It's over here, Judge.
No. All right, you got to be quiet, sir. This could go hard on the document.
Does be Jeremy accent.
Okay, I got it. All right. Let's go back on the record. Mr. Zorani, do you have anyone?
I have Minoni Gardner, Judge.
Ms. Gardner, are you there? I think, all right, Mr. Zorani, let me call the City of Detroit versus Jorge Luis Ochoa Perez, case number SP 118877, count 1 and count 2, SP 15852611, SP 165658, count 1, 2, and 3, SP 1662500, count 1 and count 2. Appearance for the record, please.
Bob Zaranick for the defendant, Your Honor. Please state your name, sir.
Jorge Luis Ochoa Perez.
Morning to you, sir. I'm going to put you in a breakout today at the time set for a free trial. I'll put you in a breakout room. Mr. Zoranick is going to get you an update on the time. If you don't like the offer, sir, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out. Let's pass the matter. Let's go back on the record with Mr. Mr. Gohar, I'll give you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client was able to show valid insurance as well as registration. We seek dismissal for having valid documents.
Our case dismissed, sir. If it's nothing further, have a very good day. Best of luck to you.
Thank you, Honor. Thank you so much.
You're welcome. All right, let's call the City of Detroit versus Kana Okai. Case, did I get the pronunciation right, ma'am?
Yeah, Kana Okai.
Okay, turn your camera on, please. City of Detroit versus Kana Okai, case number SP 174-75961. Appearance for the record, please.
Edward S. Berry Jr. on behalf of the defendant. State your full name, Ms. Okai.
Kana Okai.
Your Honor, for purposes of arraignment, my client would stand mute.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Mr. Okai, Mr. Berry is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to this trial. Please let us know what you want to do when you come out, okay? Let's pass the matter. Let's go back on the record with Mr. Roger Williams Lewis. Mr. Lewis, I'm giving you an opportunity to speak to counsel. Counsel, your client wants the trial date.
Yes, Your Honor.
Mr. Lewis, I'm going to give you a trial date for September 12th, 2025 at 9 a.m. Something further. I wish you the best of luck, all right?
Yes, sir. Thank you. September the 12th. Okay.
Jamal Glover.
Yes, Your Honor.
City of
So I can
Detroit.
lean out there?
City of Detroit versus Jamal Glover, case number SP 174-9145, 1-2, SP 174-9150.
Your Honor, Pauline Soroki on behalf of the defendant.
Mr. Glover, good morning. You state your name for the record, please.
Jamal Glover.
All right, today is the date and time set for a show cause, Mr. Cherokee.
At this time, we waive the formal reading the information and stand mute to the charges, Your Honor.
All right, enter a not guilty plea on your client's behalf. Give your client a $0 bond. Your client has some other matters.
Can I have a moment to speak with you?
Speak to Mrs. Salome first, okay? Well, yes.
You said Jamal. Okay.
He has a 20 to 25 over and a no insurance proof. Get him an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to. Join the room. Let us know what you want to come out. Okay?
Thank you.
All right, let's go back on the record. Let's pass that matter. Let's go back on the record with Mr. Perez, Oshoa Perez. Mr. Oshoa Perez, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do? Mr. Zoran, your client wants a pre-trial. I'm going to set up a trial date.
Oh, Judge, I heard a different name. I'm sorry. Did you call Oshoa Perez?
Yes, I'm going to set up a trial.
Yeah, I mean, we can, Judge. He just wants to, he just needs a little more time to bring in his insurance and license.
All right, Mr. Ochoa, I'm going to give you a trial date for September the 12th, 2025 at 9 a.m. If there's nothing further, sir, have a very good day and best of luck to you.
Thank you, Your Honor. You too.
You're welcome. This is the City of Detroit versus Jerron Omega Leverett Jr. Case number SD 1746997. Counts 1 and counts 2. Appearance for the record, please.
Bob Zoranek for the defendant, Your Honor. Please state your name, sir.
What's up there?
Mr. Leverett, please unmute and state your name. I'll send you a prompt.
Jerron Leverett.
Thank you.
All right, Mr. Leverett, good morning to you. Today is the date and time set for a pre-trial. He has a seatbelt ticket as well. Mr. Zorani, give Mr. Leverett an updated offer. Keep in mind, if you don't like the offer, Mr. Leverett, you have an absolute right to a trial. I'll put you in a breakout room, Mr. Zorani. Let us know what you want to do when you come out, okay?
Good morning and thank you. Appreciate it.
We'll pass the matter.
Judge Mione Gardner said she was back in the waiting room.
Yes. That's for all right, this pass them out. Let's go back on the record with Ms. Gardner. Mr. Zoranic, what does your client want to do?
Judge, we have a plea on one ticket and set a bench trial on another ticket.
Why don't we just set a bench trial on all of it?
Well, we can.
Yeah, I mean, that way you get a global resolution instead of pleading today and then maybe having to plead again and all that kind of stuff, right?
Yeah, we were just hoping. Okay, yeah, whatever
So
works for the court.
Let me understand what's behind it.
Well, the one ticket she would just plead to a seatbelt civil infraction, and then if the other matter was dismissed, she'd be done. So that's what we were
talking about. Pleading to the seatbelt civil infraction and all the cases related to that will be dismissed and then come to court on the marijuana and open outlaw.
Right.
Yeah, those were on separate days. I don't have any issue with that.
All right. I think that'd be good because hopefully she can resolve all this with just the seatbelt ticket then.
Well, if you want to take the deal today, ma'am, and plead to the seatbelt, pay the $65 and set the other two matters for we're set. All right. Stipulate to the face of the ticket as an active factual basis for that responsible plea on your client's behalf?
Yes, Your Honor.
Stipulate the probable cause for the dismissal of the other matter?
Yes, Your Honor.
Oh,
There should be 3 other tickets being dismissed, 3 other counts. Or actually, it's the whole other ticket, Judge, which has 3 counts. It's the 9011, 1, 2, and 3 would be dismissed.
Yeah, I know that. I'm just,
Okay.
Was this discussed with the city attorney?
Yes.
Client responsible to that charge. The other matters. And then let's set another, you an appointed attorney on these other tickets?
That might be the best, Judge.
We get the phone number from you, ma'am.
313-656-9854.
I'm gonna set another pre-trial for the September the 5th. That pre-trial date is set for you to appointed attorney to reach out to you. That appointed attorney does not reach out to you by the September the 5th. We'll get one appointed to you on the spot. If that, and then we'll move on from there. I need you to answer the calls you don't recognize. One of those calls should be that appointed attorney. All right. If you have any further questions, ma'am?
No.
I'll see you back on September the 5th at 8:30. Best of luck to you.
Thank you.
Thank you, Your Honor.
Mr. Salac, this is the city of Detroit versus Jerry Lee Graham, case number SB 1750597. Counts 1 and counts 2, and then U5259529, and then U66370223. Hearing for the record, please.
Bob Zaranick for the defendant, Your Honor. Please state your name.
Jerry Lee Graham, press *6 to unmute yourself, please. *6 to unmute yourself, please. He has a U ticket that was in 12/14/2019. That's a violation of night ordinance. That was written by Officer Knock. And then another ticket that was 2/8/2023. That was a alcohol related violation. And those are in warrant status. Unmute yourself, Jerry Lee Graham. Press *6 to unmute yourself. Send him the prompt. You need to state your name for the record, sir.
Jerry Graham.
All right, good morning to you. Day is date and time. Set for a pre-trial on the one, the other ones are on warrant status for purposes of the warrant counsel.
Yes, that the warrants be set aside, Judge.
Oh, you have somebody else. You have someone else.
Yeah, I got somebody in 5, but
all right,
if you want to put him in 6, I'll get to him.
All right, Mr. Graham, I'm gonna give you a $0 bond. I'm gonna enter not guilty plea on your behalf. I'm gonna put you in a breakout room. Wait on Mr. Zaranick to come talk to you, okay?
All right, thank you, sir.
If you don't like the offer, he's gonna get you an updated offer. If you don't like the offer, you have an absolute right to a trial.
I understand.
Mr. Graham, is this the best number to reach you?
Yes, sir.
Okay, join the room. Wait on Mr. Zaranick. Pass the matter. He said Jerry. No, Jerry. Yeah. All right. Go ahead and speak to Mr. Leverett at breakout 5, and then all right. Let's go back on the record with Miss Okia. Miss Okia, did I get the pronunciation? Okai, I'm sorry. Let's go back on the record with Miss Okai. Do you know Miss Okai's file?
Miss Okai.
Kana Okai. This is Mr. Berry. What does Ms. Okai want to do?
Your Honor, Mr. Okai has shown valid insurance. We seek dismissal for valid documents.
I'm gonna dismiss the case, Ms. Okai, for providing valid documentation. If there's nothing further, ma'am, I wish you the best of luck. Have a very good rest of your day, okay?
You as well. Thank you.
Thank you. Galarza here, Ishmael Galarza.
Good morning, Mr. Warner.
Good morning to you, sir.
I need translator, Spanish.
Spanish interpreter, can we get Spanish interpreter for Mr. Ishmael Galarza, please? Okay, we've already requested one.
Excuse me, Your Honor.
Officer Brandon, no driving in court.
Yes, sir. I do apologize. I was just called to a situation for Mr. Godbot.
Godbot never showed. Godbot, is Godbot here? Is Godbot here? Godbot never showed, so oh, he is here, he is here, he is here. All right, I'm gonna put you in the waiting room until you get to a safe place. I'll put you out until you get to a safe place to call back in when you do.
Yes, I'm here.
Officer Brandon.
Officer Wilson.
Yes.
This is Mr.
Okay. Donovan Godbot is here?
Donovan Godbot is.
Okay.
This is returning.
Yes, I'm here.
All right. All of these officers are here for Godbot? Yes. Let me let that officer get back here. Rashard Gray. See if Trey.
Yes.
First, Rashard Gray. Case number SP 1743771, SP 173-43791. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gray.
Rashard Gray.
All right, today is the date and time set for a trial. Good morning to you, Mr. Gray. Is Officer Chapman here? Officer Chapman. I don't see an Officer Chapman on my list, Mr. Berry.
The motion is for dismissal, Your Honor, there being no complaining witness.
Case dismissed, Mr. Gray. Have a very good day. Best of luck to you.
All right, thank you.
All right. All right, let's go with Mr. Berry. We have Chris G. Who is Chris G? Good morning to you. First camera, state your name, please.
Morning, Your Honor.
Good morning. What does Chris G stand for?
My name is Christopher Gibson. For Wendell Gibson.
Is that G-I-B?
Like Mel Gibson, the actor.
Say G-I-B?
Yeah, G-I-B-S-O-N.
Say Christopher. I don't think I know Christopher Gibson. I probably do know him. I just don't know him by name. Who does he play in? Who's your
Are you
middle name, sir?
And
You have a bad connection. What is your middle name, Mr.
I'm sorry.
Mr. Christopher Gibson? What is your? Say that again.
Okay.
You see him?
Yeah.
Where?
He's on under 9 o'clock, right in the middle.
Lee Gibson?
Christopher Wynn.
Wynn. Like Steve?
Like W-E-N. He's right above Donovan Godbot.
City of Detroit versus Christopher Wendell Gibson, case numbers SP 1722758, count 1 and count 2, SP 172278811. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gibson.
Christopher Wendell Gibson.
One, you serve date and time set for trial. Is there an Officer Randall, Jasmine Randall? That officer I do not have on my list.
Your Honor, the motion is for dismissal, there being no complaining witness.
You're batting 1,000, Mr. Berry.
Yes, sir, it's Friday.
Have a good day, Mr. Gibson. Best of luck to you. Case dismissed, all right?
Thank you, Mr. Berry.
You're welcome, Mr. Gibson.
Jeremy Gates, is that Gates? Jeremy Gates.
Yeah, Your Honor, Jeremy Gates.
Good morning to you, sir.
Good morning to you as well.
City of Detroit, Mr. Berry versus Jeremy Gates. I know he hopes you keep your batting average up. Case number SP 1157929, counts 1 and counts 2, and counts 3. SP 1724800, counts 1, 2, and 3. SP 1732501, counts 1 and counts 2. SP 1733806, counts 1, 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gates.
Jeremy Gates.
All right, today is the date and time set for a trial. We'd like to hear from Jeremy Gates. So I have Al Hadley, Officer Al Hadley here.
Yes, Your Honor.
Good morning. Can you state your name, badge number, and department for the record?
Officer Al-Hadimi, badge 1563, Detroit Police Department.
Good morning to you.
Morning to you as well.
All right, Officer Stuckey is here. Officer Stuckey.
Yes, good morning.
Name, badge number, and department for the record, please.
Officer Trevor Stuckey, badge 4659, Detroit Police Department.
Good morning to you. Officer Han, good morning to you. Can you state your name, badge number, and department for the record, please?
Good morning, Your Honor. This is Officer Fuhan, badge number 2612, Detroit Police Department.
Good morning to you. And is there an Officer A. Williams? A. Williams. I do not see Officer, oh, A. Williams is here. Officer Williams, can you put your appearance on the record, please? Was here, so give Mr. Gates an updated offer, Mr. Berry. Keep in mind, if you don't like the offer, Mr. Gates, you have an absolute right to a trial. I'm gonna put you in a breakout room. Let us know what you want to do when you come out, okay?
No problem.
Forgive my interruption when you get a chance.
Yeah, Mr. Walsh.
So Mr. Liddell, I have him on the telephone and he's having trouble logging on to Zoom. Can I introduce his audio into the meeting by way of my Zoom?
What are we setting it for?
Trial September 9.
Right.
Mr. Liddell, are you there?
Yes.
Okay, stand by.
Gotta figure it out by the day of the trial.
Yeah, oh yeah, we definitely will.
City of Detroit versus Richard Edward Liddell, case number SP 1649761, count 1 and count 2. Appearance for the record, please.
Good morning, Harry Boffman, P55052 on behalf of the defendant. Sir, state your name for the record, loud and clear.
Richard Liddell.
Did you hear that, Your Honor? Okay, so can we have a bench trial date? My client's been advised.
The trial date is going to be September the 9th, 2025 at 9 a.m. If there's nothing further, sir, have a very good day. That's enough for you. Anybody else, Mr. Bob?
That's everything. Thank you, Your Honor. Have a great weekend.
I do as well.
Bye.
All right, let's go back on the record with Mr. Glover. Mr. Glover, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, the people have offered, my client would admit the reduced count of limited access 6 to 10. The other counts would be dismissed. He's waiving his rights and asking court to adopt that.
Mr. Glover, did Ms. Soroki obviously answered all the questions you needed, right?
Yes.
You still need to ask me anything?
No.
All right. Did you want to take the deal?
Yes.
Stipulate to the face of the ticket as an active factual basis for the responsible plea on the client's behalf, Ms. Soroki.
So stipulated.
Stipulate the probable cause for the dismissal of the other matter.
So stipulated.
Find your client responsible for the amended count of limited access 6 to 10, $135. When can you pay it, Mr. Glover?
I can pay it by Monday.
All right. Pay it by Monday. Pay it at any DivDac kiosk in the city of Detroit. Told you don't love that DivDac after your phone. We'll come on down to the courthouse and pay it in person. Those are the two best ways I can take you to pay it. If there's nothing further, Mr. Glover, have a very good day. Best of luck to you. All right.
Thank you.
All right. Good morning to you, Ms. Cox.
Good morning, Your Honor. Good morning.
Can you state your name for the record, please?
Maria Cox, COX.
Can you raise your right hand, please? Do you solemnly swear or affirm that you'll tell the truth, whole truth? Strike that. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court, not divulge confidential communications? So help you God.
I do.
You swear or affirm to the best of your ability you'll interpret from English to Spanish, Spanish to English?
I do.
This is the city of Detroit versus Ishmael Galarza Roman, case number SP 171-75-641. Appearance for the record, please.
Llamando el caso contra el señor Ismael Garza Gómez, el caso SP 17175641. Por favor, digan sus nombres para las escrituras.
Ismael Galarza.
Your Honor, Pauline Soroki on behalf of Mr. Glaza.
La abogada Soroki, representando al señor Galarza.
Today is the date and time. Good morning to you, Mr. Garza. Today is the date and time set for a trial.
Buenos días, señor Galarza. Hoy es el día y la fecha para un juicio.
Buenos días, señor juez.
Good morning, Your Honor.
Is there Officer Aramonte here?
¿Está el oficial, el policía Garbanti hoy aquí?
Moranzi.
Moranzi, de apellido Moranzi.
No response.
I'm going to move for dismissal, Your Honor. Today's date time set for trial.
Como no se presentó el abogado Sonoría, a nadie contestó, voy a pedir que anulen el caso porque no se presentó.
Good morning, have a good day.
I'll grant the motion. Have a good day, sir. Case is dismissed. Best of luck to you.
Entonces, yo concedo esa petición. El caso y sus cargos quedan anulados. Que tenga buen día.
Muchas gracias y buen día.
Thank you so much. Have a good day.
Thank you, Ms. Cox. Nothing further. You have a very good weekend, okay?
Thank you so much, Your Honor.
You're free to leave.
Thank you. Se puede desconectar, señor Galarza.
Gracias.
Thank you.
This is the city of Detroit, Mr. Ropi versus Valita Lane, case number SP 1663579, counts 1 and counts 2, SP 173193881, SP 1731943, counts 1 and counts 2. Appearance for the record, please.
Your Honor, Pauline Soroki on behalf of Ms. Lane.
Good morning. Good morning. State your name for the record, Ms. Lane, please.
Valita Lane.
All right, good morning to you, Officer Mitchell. Good morning to you. Can you state your name, badge number, and department for the record, please?
Officer Mitchell, badge 2125, Detroit Police.
Good morning to you, and Officer Green. Good morning to you. Can you state your badge number, department, and for the record, please? Officer Green is doing. Let's go put you in a breakout room, Ms. Lane, and have a conversation with Ms. Ropi. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay, thank you so much.
You're welcome. Join the room. Let us know what you want to do when you come out. All right, let's pass the matter. Let's go back on the record with Mr. Leverett. Mr. Leverett, you want a trial date, sir?
Yes, sir.
Were you trying to get an appointed attorney?
Yes, sir.
All right, I'm going to set a pre-trial date for you on September the 5th, 2025 at 8:30. I need a good phone number from you.
Yes, 313-575-5260.
All right, I need you to answer the call. If you don't recognize one of those calls, should be that appointed attorney. Come back on September the 5th, 2025. If that attorney hasn't contacted you by then, we'll get one appointed to you on the spot, okay?
Okay, I do have a quick question for you, Your Honor. Is it possible if we can reschedule that day? I'm not sure. I have drill that day. I go to drill that weekend, that Friday morning. I'm not sure how busy we are going to be. If I can, be able to take that time out to take the Zoom call, so I would rather reschedule.
Come back on the 4th.
On the 4th, that's fine. That's perfect. Day before, that's perfect.
All right, and she's set to make sure that attorney has contacted you, all right?
Sounds good. Thank you.
If not contacted you, we'll get one appointed to you on the spot on that day.
Okay, on the 4th at 8:35?
8:30. Best of luck to you, sir. Have a very good rest of your day.
Thank you.
Gladen, I see your hand is raised.
Hey, y'all better sit down.
How can I help you? All right, let's go back on the record with Mr. Gates. Mr. Gates, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client would avail himself of the people's offer to enter a plea to 5 of the 10 charges, those being.
All right, let me stop. Oh, he already, this is statement set for time of trial. All right, go ahead.
Failure to display, 2 improper plates, the expired plate charge, and the seatbelt charge. The remaining matters to be dismissed.
You want to take the deal, sir?
Yes, Your Honor. Yes, I do.
Can you raise your right hand, please? Where are you? Turn your camera on.
You can't hear me?
I think I turned it off because you were slow.
Okay. Does it start my video?
Yes. Raise your right hand, please. Do you swear or affirm to excuse me? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
I do.
Say that again.
I said I do.
Okay, put your hand down, sir. You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines? I didn't hear you.
I guess I do.
Let me stop your camera now. Maybe it's gonna help with transmission of the device a little better. You understand that you have an absolute right to a trial?
Yes, I do.
Mr. Berry went over your other advice or rights in the breakout room, did he not?
Yes, he did.
You understood those rights?
Yes, I did.
You have any questions about those rights?
No, I do not.
You know, by taking the deal, you're gonna give those rights up?
Yes, I do.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to June 18, 2025, around 6:36 p.m. in the city of Detroit, in the area of McNichols and Ward. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes, I do.
Was it your 2007 Dodge?
I believe it's a Dodge. Yes, it's a Dodge Caravan. No, that was not my vehicle.
You were operating that vehicle, right?
Yes, I was operating it.
And did the officer ask you to produce a valid driver's license?
Yes, he did.
You couldn't do so, could you?
No, I do not have a valid driver's license.
Find guilty of the admitted count of failure to display. Were the plates expired on that vehicle?
Yes, they were.
And did you have a seatbelt on?
No.
Find him responsible as charged to both the seatbelt and the expired plates. Let me draw your attention.
You need what's your plate number, boss? MOP. Your features, no accidents, right?
Back to May the 21st, 2025, around 4:22 p.m. in the city of Detroit, in the area of McNichols and Ashton. Did you have an occasion on that day to come and call with the Detroit Police Department?
Yes.
You're operating a motor vehicle?
Yes, I was.
That was a 2008 Dodge, right?
It was the same vehicle. That's why when you said, I'm not sure about the year, but it was for sure the same vehicle.
One person wrote it as a 2007, the other wrote it as a 2008. Then you didn't own that vehicle, did you?
No.
You were operating that vehicle, correct?
Yes, I was.
Officer asked you to produce a valid driver's license.
Yes, he did.
Couldn't do so, could you?
No.
Because you didn't have one?
No, sir.
Was there something wrong with the plates on that vehicle, sir?
I believe.
No, not whether you believe.
Here, you broke up a little.
It's not whether you believe, you have to know.
The plates wasn't. I think it was no, I think they was expired or something. It wasn't right though. Place wasn't right.
How do you know that?
Because I had received the ticket for it. I don't remember exactly what ticket.
Yeah, but you know, this is not your car, you indicated, right? He's breaking up. Is this your car or not? Yeah, is this your car or not?
No, it's not. No, it's not my vehicle.
Do you know whether the plates were valid or not?
I knew that the plates weren't valid.
You knew that the plates weren't valid before you got in the car. You knew that before you got in the car?
Yes, I did.
Find him guilty.
Yes, I did.
Charge the improper plate. Stipulate the probable cause, will dismiss the other matters.
So stipulated, Your Honor.
I'm gonna fine him. I'm not gonna fine you for the. I'm gonna give you the same break I gave the other gentleman. I'm only gonna fine you for 3 of them. I'm not gonna fine you for the other 2. $240, $240, and $240. And I'll dismiss the improper plate and the allowing upon payment. And I'll waive the warrant fees. I don't see any reinstatement fees. When can you pay it, sir?
I would say today, but it would be no later than Monday.
All of that?
If you said it was 243 times?
Yes.
I can do at least 2 of them.
All right. Well, when let's give you 2 weeks to figure it out. You got to come back anyway to make sure that the stuff is closed out properly. Come back on 5th of September, 2025. All right. You don't have any questions.
You said September 5th, what time?
At 8:25.
Okay.
Don't have any further questions. I wish you the best of luck. Have a very good rest of your day.
Thank you, Arnold. You have a good day as well.
Let's go down to Kathy Lyons. Is Kathy Lyons here?
Yes.
Warren City of Detroit versus Kathy Lyons, case number SP 11422201. SP 117683, counts 1 and counts 2, SP 1217756, counts 1 and counts 2, and counts 3. SP 1232333, counts 2 and counts 3. SP 1421884, counts 2 and counts 3. SP 164934661, and counts 1 and count with SP, strike that. SP 1649346, counts 1 and counts 2. SP 1656271, counts 1 and counts 2. SP 892169, counts 1, 2, and 3. 19 385 3771. Appearing for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lyons.
Kathy Denise Lyons.
All right, good morning to you, ma'am. Today's time set for a pre-trial. Ms. Lyons owed $288 on one no insurance civil. She owes a few other civil infractions as well, but that no insurance civil can potentially set herself up to get a valid license if she paid it. Mrs. Lyons, I'm going to put you in a breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to the trial.
Okay.
Let us know what you want to do when you come out, okay?
Okay.
All right, let's go back on the record. Let's pass the matter. Let's go back on the record with Mr. Graham. Mr. Graham, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Judge, we have a plea worked out.
All right, you want to take the deal, Mr. Graham? He must have fallen off.
I just saw him on here.
I don't see him anymore.
Yeah, he's on there. Mr. Graham.
Mr. Graham? Mr. Graham? He must have fell asleep. All right, let's pass him.
Hello.
Mr. Graham, are you there?
There he is.
Yes.
You want to take the deal, sir?
Yes, sir.
All right, raise your right hand, please.
Okay.
Swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, you put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, I understand.
You understand that you have an absolute right to a trial?
Yes.
Mr. Zoranic went over your other advice or rights in the breakout room, did he not?
Yeah.
You understood those rights?
Yes, I did.
Do you have any questions about those rights?
No, I'm just trying to find how much I owe.
All right, you know by taking the deal, you're going to give those rights up?
Yes, I know.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
What's he pleading to, Mr. Zoranic?
On the docket, Judge, there's two tickets, 971 and 972. 971 will be dismissed. 972 will be reduced to improper plates. He also has two other tickets, Judge. They're two U tickets. One ends in 233. That's an alcohol offense. That'll be dismissed. And the other one ends in 219. That's a violation of knife ordinance. That'll be a 6-month delayed sentence.
That's Knox's tickets, the violation of knife ordinance. You want to plead to that?
Yeah, he was going to do a 6-month delayed sentence on that.
All right. You want to take the deal, sir?
Yes, Your Honor.
All right, let me draw your attention back to July the 3rd, 2025, at around 10:47 p.m. in the city of Detroit, in the area of Woodward and Sheldon. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes, I remember.
Were you operating a motor vehicle?
Actually, I was pushing it, but I guess you call it operating it. I guess that's what it was. I wasn't driving when they pulled it. I was pushing it because they had cut off, and I was trying to push it to the side. So I guess that's operating. I don't know.
I don't think that would be. I don't think you can push a vehicle without operating a vehicle.
Well, I was outside trying to push it out in the middle of the street.
So what, but it was on a public city street, sir, that the car was on?
Yeah, it was on Shelby and Woodward right there.
But it wasn't operating.
No,
I think it would still have to
off.
be insured or registered to be on the street, Judge.
Okay, it wasn't insured. Whether I had just got the car, I didn't make it.
Is your vehicle, sir?
Yes, it was.
And you didn't have insurance on that vehicle?
No, I didn't.
All right. Find the client guilty of the amended count of improper plate for not having the insurance. Let me draw your attention back to way back to December the 14th, 2019, at 1331 Broadway Street, in the city of Detroit, at about 2 a.m. Did you have contact with the Detroit police on that day?
Yes, I did.
Did you have a knife on you, sir?
Yeah, I had a knife on me.
All right. It just says subject in possession of switchblade knife. It doesn't give me any facts to relate to why it was illegal.
So, sir, was the blade on the knife longer than 3 inches?
Yeah.
And it was a switchblade, correct?
No, a pull-out book knife, like a little pull-out, folding knife.
All right. Either way, Judge, it's a violation of the ordinance.
Because the blade is longer than
Yes.
3 inches. All right, find you guilty as charged. Stipulate the probable cause. I'll dismiss the other matter. Ryan?
Yes, Your Honor. We'll stip the probable cause. Thank you.
All right. I'm not gonna fine you for your car breaking down and not having insurance. I'm gonna fine you $240 for the switchblade knife. 243-month delay. I'm gonna give you until November the 24th, 2025 to pay it. And if you don't get any other trouble like that, then the matter is paid by November the 24th, 2025. We'll dismiss the case, okay? Come on back that morning. When you pay it, then you div that kiosk in the city of Detroit. I'm told you can upload the div that app to your phone, or you come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. If you're nothing further, sir, November the 24th is your next court date. Have a very good day, all right?
So let me ask you a question. So that's all, the whole total is 240 or
240.
That's the whole total for everything.
For everything.
I had it paid before. That's my birthday, November 24th. So I had it paid by then.
All right, we'll see you back on your birthday then.
All right. So do I bring them? I can take the money at 36. Can I pay that, right?
Yes, you can do that.
Okay, I'm not far from there. All right, thank you, sir. I appreciate it. Have a good weekend.
All right, you as well.
All right, bye.
This is the city of Detroit versus Bernice Gladen. Case number is SP 16633-451, SP 1-474-2011. Appearance for the record, please.
Bob Zaranick for Miss Gladen, Your Honor. Please state your name, ma'am. You have to unmute.
Gladen.
Thank you.
Ms. Gladen, day, date, and time set for a arraignment counselor. on the bench warrant.
Arraignment, yep. We'll waive the formal reading of the information, Judge. We'd like to set aside the bench warrant.
One or not guilty, Ms. Gladys, if you have, we'll give her a $0 bond. And all right, for SP 147-42011, I'm gonna dismiss that case. It's been paid. Get Ms. Glad an updated offer on the other case. Ms. Glad, if you don't like the offer, you have an absolute right to a trial, okay?
Okay.
Join the room, let us know what you want to do when you come out. Pass the matter.
Judge, did you already do Taryn Leverett?
Yes.
Okay, we were going to set up for a bench trial, but you probably did it while I was in the breakout.
Appointing him an attorney, he's gonna come back for a pre-trial on the 4th of September.
Okay, good. Thank you.
All right, let's go back on the record. Let's pass that matter. Let's go back on the record with Ms. Lyons. Ms. Lyons, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor.
Hold
I'm
on,
sorry.
hold on. Let's see, Lyons needs an appointed attorney.
Yes, Your Honor.
The appointed attorney ever contact you, Ms. Lyons?
No.
All right, Ms. Mathis, can you get an attorney in here now? She wanted to appoint an attorney last time. Let's pass the matter. Mr. Berry, oh, that's Lyons. Wait a minute, which one is one? That's not here. Which one is that? Mr. Berry, let's call the City of Detroit versus Donovan Godbot. Case number SP 12120. Strike that SP 121-27001. SP 1253. Strike that. SP 125-22333. SP 125-61003. SP 125-61021, SP 1288495, counts 1, 2, and 3. SP 1297956, counts 1, 2, and 3. SP 15723-881. SP 1629017. SP 1689831, SP 1732312, count 1, counts 2. SP 17323. That's right, but SP 1732332, counts 1 and counts 2. SP 1734125, counts 1, 2. 3, SP 1734142, counts 1 and counts 2, SP 886503, counts 1 and 2, SP 9758113, counts 1, 2, and 3, SP 19418278, counts 1 and counts 2. Appearance for the record, please.
Les Berry Jr. On behalf of the defendant, state your full name, Mr. Godbot.
Donovan Godbot.
Good morning to you, sir.
Good morning. How are you?
I'm well, thank you. For appearances for Godbot,
It's gonna be Officer Coleman here for Godbot.
good morning to you, Officer Coleman. Next badge number, department, please.
I'm sorry, 1 second, Judge.
Your Honor, Officer Maverick Lunguski, badge 746, Detroit Police, also here on Mr. Godbot.
Good morning to you, Officer Nusky. Officer
30.
Zakio. He was here.
Officer Coleman here for Godbot also, sir.
Yeah, and state your name, badge, and number and department, please.
Officer Coleman, badge 337, Detroit Police Department.
All right, good morning to you.
Good morning.
Officer Brandon is here. Officer Coleman is here. Officer Gusky's here. I haven't seen Officer Wright. Mr. Berry.
We move for dismissal, Your Honor.
I don't know the other three officers on that 19 case. I haven't seen Officer White, Officer Presley, and Officer Sherry. All right, so we'll grant the motion to dismiss on those officers. Get Mr. Godbot an updated offer. Keep in mind, Mr. Godbot, if you don't like the offer, you have an absolute right to do a trial. Put you in a breakout room with Mr. Soroki. Let us know what you want to do when you come out.
Okay, thank you.
Mr. Berry, join the room, please. Let's pass the matter. All right. All right, let's go back on past that matter. Let's go back on the record with Ms. Lane. Ms. Lane, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we did reach a resolution with the city attorney, the suspended license being amended to fail to display. And I believe the other charge was expired plate violation. All other counts are being dismissed.
I don't have an expired plate.
I'm sorry, registration, no registration.
Yeah, it's a misdemeanor though. You want to take the deal, ma'am?
Yes, Your Honor, I do.
Can you raise your right hand, please? You swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes, I do.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense for 93 days in jail and or $500 in fine?
Yes, I do understand.
You understand that you have an absolute right to a trial?
I understand that as well.
And Ms. Soroki went over your other advice or rights in the breakout room, did she not?
Yes, she did.
You understood those rights?
Yes, I did.
Any questions about those rights?
No, not at all, Your Honor.
You know, by taking the deal, you're gonna give those rights up?
Yes, I do.
Has anybody offered you anything other than what's been stated in the record? Can we get this?
No, they have not.
All right. I'm gonna draw your attention back to May 24th, 2025, around 9:00, strike that around 6:09 p.m. in the city of Detroit, area of Gratiot 7 Mile. Did you have an occasion on that day to come to contact with the Detroit Police Department?
Yes, I did, Your Honor.
Were you operating this 2000 Lexus?
Yes, I was, Your Honor.
Did the officer ask you to produce a valid driver's license and registration?
And I was unable to do both.
And why is that?
Because the car was not registered and I did not have a valid license.
Very well. Find your client guilty of the amended count of improper plate for the not having a valid for not having a valid registration. And then what was the other amended count, Ms. Soroki?
Your Honor, it was going to be failed to display, but she did say that would be the expired plate. So could you amend the like the improper U-turn to the expired plate? Because if you look, the one gets listed as a civil.
I don't have a problem with that.
Thank you.
All right. So I won't find you guilty of improper placement. I mean, I'll dismiss the no registration, stipulate to the face of the ticket as an accurate factual basis for that response, please.
So stipulated.
And I'll find you guilty for the amended count of failing to display for the not having a valid license with stipulation to proper cause, will dismiss all the other matters.
So stipulated.
All right. I'll waive the warrant fees for you, ma'am. 240 and 145, when can you pay it?
If the total is 240 and 145,
Yes.
I can make a payment on the
385.
385 completely, and I can pay the remainder balance this coming up week.
Say it again. When can you have it all paid? Just give me a final date. You can pay it any kind of way you want to pay it.
By next week, I can have the total balance paid off, sir, Your Honor.
You want to pay it? I'll give you until 9/5/2025 to pay it off. Pay it, then you did that kiosk in the city of Detroit, Miss Lane, or I'm told you can upload the did that app to your phone, or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. And something further, Miss Lane, have a very good day. Best of luck to you. All right.
Thank you as well. Have a wonderful weekend.
You too. Now let's go back on the record with Ms. Gladen. Ms. Gladen, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Yes, I had a chance to speak with counsel.
You want to set a trial date, Ms. Gladen?
Yes, I do.
Yes. You want the appointment of an attorney?
Huh?
You want an appointed attorney on this matter, or you want to just set a trial date?
Just set a trial date.
Trial date is going to be September the 12th, 2025 at 9 a.m. All right?
Okay, via Zoom, correct?
It's like Burger King now. You have it your way.
Okay.
Via Zoom. All right?
Okay. Oh, one more thing. Did you get the payment for the last ticket?
I dismissed the case. Yes. Because you paid it. That was the deal. You pay it, it'll get dismissed. I dismissed it now.
Okay, because I gave them $200 and something for the ticket.
I know. I told you it was dismissed upon payment. And I saw that you paid it, so I dismissed it.
Okay,
so
thank you.
You're supposed to give them the $240, but we dismissed it because you paid it.
Okay.
All right.
Thank you.
Best of luck to you, Ms. Glad.
Okay.
All right, we're waiting on an attorney. Ms. Cox, you've already been sworn in. This is the city of Detroit versus Pablo Huber Gomez, case number SP 174-9798, counts 1 and counts 2. Appearance for the record, please.
Se llamaron el caso contra el señor Pablo Gómez, SP 1749798. Por favor, digan sus nombres para las escrituras.
Pablo Ever Gómez Gómez.
Appearance for the record, please.
Your Honor, Pauline Soroki, the defendant.
Su honoría, la abogada Pauline Soroki, representando al acusado.
All right, Mr. Gomez, Mr. Soroki, good morning to you. Mr. Soroki is going to get you an update. Mr. Soroki is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. We'll put you in a breakout room with her. Let us know what you want to do when you come out.
Ese señor López Gómez nos van a mandar a un cuarto privado para que la abogada le dé a usted una oferta. Si usted la quiere aceptar, cuando regresen le dice al juez qué quiere hacer, pero usted tiene un derecho absoluto de no aceptarla. Por favor, cuando vea en su pantalla que diga join, oprima ese botón o unirse.
No, está bien, gracias.
Okay, that's fine, thank you.
And Judge, can I get a moment before we go to the next case?
Yes. Tell us, Thomas. You got full. I think you do. I don't.
What kind of phone?
He's
trying to. And we should hammer him up in the back hallway.
There you go. I'll let you do that. You see him?
You know, you think something, they was calling my name like a hero.
You'll be sending everybody down there to stand.
Oh, it was just
I
me.
thought you were 30.
Oh, you could say it just. 30 or more, 220. Pay 2 tickets and everything else. Wow.
Make some money then.
Yeah, they all be out there. What?